Planning Commission meeting of Wednesday, 21st of June, 2017. And with that, all please stand for the Pledge of Allegiance. Put your hand over your heart. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Will City Planner please call the roll?
Yes, Eggleston. Commissioner Eggleston, sorry. Sorry.
Here.
Commissioner Blackwell.
Here.
Commissioner Talley. Commissioner Brown.
Here.
Commissioner Crandall.
Here.
Commissioner Wu.
Here.
And please note that Smith and Talley are absent tonight.
Okay, there are no special orders of business tonight. With that, we'll go on to item 5A, the minutes from the study session and regular meeting of June 7th, 2017. Are there any comments or a motion to approve?
I have any comments about the vote on that item. As I recollected, Mr. Smith voted no on that.
He did.
That was 8B on page 7 toward the bottom. It was moved by Commissioner Blackwell, seconded by Vice Chair Crandall, and unanimously carried. I believe that was 6-1.
Well, there
That's
was
correct.
one abstention too, because Commissioner Eggleston had recused, right?
No, he was here for the deck.
Okay.
This is the deck, yeah.
You're correct. Okay, let's amend that, please.
So it would be 6-1 is a drop.
6-1 with Mr. Smith opposing.
Good catch.
You want to make a motion to approve that?
Sure. I move to approve the minutes of the adjourned regular meeting of the City of St. Clemente Planning Commission on June 7, 2017 at 7 p.m. City Council Chambers, 100 Avena Presidio in St. Clemente, California, with the revision that on page 7 for item 8B, it was carried to adopt the resolution 7-1 with Commissioner Smith opposing.
6-1.
6-1.
Do I have a second? Second. Mr. Blackwell, a second. Do I have a motion to approve?
Aye.
Aye. Carries 502. With that, there are oral written communication. Members of the audience may address the commission on matters of public interest which pertain to the city and are not otherwise on our agenda. If you wish to speak, please step forward to the microphone and state your name and city of residence and make a presentation. Please limit your presentations to 3 minutes. Are there any cards for anything that are not on our calendar tonight? Okay, thank you. There are no items on our consent calendar, and so we'll move to the public hearing. Public hearing process tonight is have a different format than normal, based on advice of legal counsel. The temporary banner permit 17194, appeal of a denial of temporary banner permit applications for the outlets of St. Clemente. The order tonight will be that the appellant will speak first and is asked for 20 minutes. Which time then the city will be able to speak for 20 minutes. We will then provide the appellant a rebuttal of 5 to 10 minutes. After that, we'll open discussion for public comment, close, and then the Planning Commission will go into discussion. With that, would the appellant's attorney like to proceed?
And I just wanted to note, since I am the planner on this project, I'll be sitting down here tonight as opposed to on the dais, for the record.
Thank you. And, members of the commission, my name is Madison Spock. I reside in the city of Laguna Niguel. I had a couple preliminary before Brad Malmud will take the main laboring war in making the presentation. I had 2 preliminary matters which were motions. Members of the commission may wish to consider my motions now or at the time you make your determination on this. You have been briefed on this. We've had an opportunity to read Mr. Burns's package. We have asked that the appeal deemed to be automatically granted because the date on which the notification of the hearing was given was outside the 10-day limit that is required by the municipal code. As a result, when I was first notified by Mr. Wright of the date of the hearing, it was beyond the 10-day period. The reason we moved for automatic grant of the appeal on that basis is that were the tables reversed, then I feel certain the city would take the position that the appeal should be automatically denied. So that's the first motion. The second is that in Ms. Gregg's memo on the first page, she recognizes that this is a ministerial application. That means that there's no discretion to deny it once it's accepted, and therefore any issues about whether the signs, the temporary banners were proper is a matter for ultimately for enforcement rather than for the initial point of the grant of the permit. And so that's the second basis on which I move. And so those are the two matters on which I move, and I just wanted to make sure that otherwise everyone had an opportunity to see the massive amount of paper and has had an opportunity to read through the various positions. We have worked out a number of items with Mr. Burns. We have filed papers which register otherwise our procedural objections, which he and I have discussed and he's familiar with. So with that, I'll hand it over to Brad for my preliminary comments.
And for the record, we received very large input from the appellant, including Mr. Malmood, all the indexes. I think most of us, I did study them, all the other permits. We've got emails that were sent to the city as late as 4:15 this afternoon on the dais, and also we received through the city outlets. With that, proceed.
Thank you for allowing me to speak. Just so you know, we didn't know what the procedures would be until we got here tonight, so we're kind of winging it. But what I think, given the materials you have, and that we're only analyzing one sentence of the municipal code, I think we can get through this in under 20 minutes. I sure hope we can. What I want to do is take you, Matt just did this, so we can skip this slide, and I think you all know there were 18 permits. 12 were denied initially, 6 were then accepted and then rescinded by Mr. Burns, but he claims he didn't rescind them. It was done by the community development director, but her name shows up nowhere. So I don't know what really happened, but let's just say they were revoked. The municipal code says that temporary banner signs shall be placed on site and flush on the building. That's the end of the applicable section you have to decide tonight. You need go no further, because that tells you where they have to be placed. On site is the entire property, and flush on the building is how they get mounted. What follows has nothing to do with that. It tells you where you can't put them, not where you can. And the city's using sleight of hand to tell you that the second sentence tells you where you can put them. We get to read this as it's written, not as the city wants to interpret it. We'll get into that in a second, but let me read it to you. Banners are prohibited in the city right-of-way, not an issue here. Freestanding walls, not an issue here. Fences or other areas or fixtures not part of the business primary structure, also not an issue here. And I'll show you why in a second. This is the permit that everybody uses. I'm sorry it's so small, but the section that's important is 3. The temporary banners must be flush mounted on the building. We've already decided we don't need to worry about that. And is not to be hung on fences, railings, trees, or shrubs. That's the description of what I just told you here was, or the business's primary structure. That primary structure doesn't show up, and the other parts, if that's what it is, are defined as fences, railings, trees, and shrubs. It's got nothing to do with the building the business is located in. And I don't know how, and we'll find out in a few minutes, how the city got to that conclusion. And maybe it isn't even from here. But the staff report doesn't tell us. It just it starts with a conclusion rather than how we get there. The city's application says exactly what I just told you. There's nothing about requiring a banner to be placed on a primary structure. And even if it was, by the way, Mr. Burns' notice is critical here. I regret to inform you that the 6 permits issued by the Outlet Mall were issued in error. They weren't issued in error. All those 6 are in primary structures. So I could read the rest of it, but it's not critical. We've already gone through it. But just understand, 6 of these banners qualify regardless of how you interpret this section tonight. Again, temporary banners must be placed on-site, flush on the building. It is not restricted to primary structures. So here's the other reason the primary structure argument doesn't hold water. Even if there were a provision that said that, we have to still look at the code. The staff report defines code. I'm just reading what it says in the code. Primary structure means a building within which the principal use or principal occupancy of a lot is conducted. It has nothing to do with a business. The code only defines primary structure as the same as primary building one time. It's not used anywhere else. We don't even know why it's in the code, but it is there. But it has nothing to do with the business itself. Okay. All 18 banners, and I don't think there's any dispute on this, are flush on the building. So the only issue in front of you is, what does on-site mean? If there's somebody here that think it means a primary structure, then I'm lost. It means any building, okay? And it says on-site, okay? That's the end of what I wanted to present as far as the slide presentation. And I hope that at least clarifies what issues you need to decide tonight. And that's that one sentence, and actually 2 words. What does on-site mean? Therefore, the city's decision was not based on the code. This is the first time the city's attempted to impose this limitation, and this section has been in place since approximately 1991. And the banner permit's been in place for forever. And the banner permit, as I showed you, does not limit this to a primary structure. That's what we've used. We started doing a California Public Records Act request, and we've gotten some responses back at about 4:30 this afternoon to some of the questions. The city's never imposed this primary structure on anybody else, but I'm going to ask Amber these questions to try to find out what's going on. So I'm going to try to skip through what I wrote here, because I think the form tells you, the application itself tells you everything you need to know, that it can be on any building as long as it's not on trees, shrubs, railing, or fences, or the city right-of-way. And if that weren't the case, the city would have had an instruction in there, it has to be on the primary business buildings, the business's primary building. That doesn't show up anywhere. And again, I'm going to tell you, it's never been enforced that way. And the practices of the city are consistent with the way I've interpreted, and I think you will interpret this section, which is on-site. I also want to tell you that with the exception of the little strip, I don't know, how many of you are familiar with the outlets? The little strip that's all relative. The strip that includes the AT&T building, Blaze Pizza, that is in one parcel. Everything else is one parcel, one lot, one address, and even that's the same address. So we're talking about one lot here. So no matter how we interpret it, it's simply a lot. And now if I could, and I want to, if I can do this in a friendly sort of way, if I can just ask Amber to help us out and ask her some questions. If she wants to sit up there, that's fine. It would probably be easier. I just want to find out how we got here, how the city came to this conclusion, how they read a straightforward statute and have always applied it. You apply for permit, you get it. It's that simple. Then there's a citation if you put it in an improper place. By the way, the city hardly cites anybody. We found that there were only 2 citations in the last 2.5 years. One was for somebody who didn't have a permit, and the other one was for somebody, two citations to them, who improperly displayed it, I think. We just got those at 4:30, but that was the only ones in 2.5 years of time. Yet, that's what's going on here. It's something is going wrong. Something doesn't make sense.
I'd like to
So
ask the city attorney, is this a presentation or is this cross-examination now? So I would like a reading on that.
Yeah, Mr. Chair, generally you do not, cross-examination would not be required in this setting. We're here
correct.
to argue about what a sentence in a statute means. In some settings, cross-examination might be appropriate, but we have a case that's pretty well the leading guiding case on these types of matters, a nuisance abatement or a permit denial case, and that's the Mohaleef versus Janovici case. And that said that cross-examination is not required, and you get to make your presentation, you get to rebut the evidence with your own presentation, and you're entitled to know what the charges are, but not cross-examination. That turns it into a different proceeding.
Thank you.
Can I speak to that issue then? That case doesn't say it's not allowed. It says it's not required. I would think you'd want to know how the city got to this position. I'm not going to make it adversarial, but I think it's interesting to know why, after 25, 26 years, all of a sudden the definition which is included on the application is changed for this one group only. How did that happen? I would think the planning board, unless you, look, if you agree with me that we're done, that on-site is done, we're done. We can just call it a day right now, and I'd be happy to sit down. If you have question whether the business primary structure is the controlling statement in this, and that banners could only be on primary structures, then I think we should find out when that started, when it's been enforced, how the city gets to that language. And if you won't let me ask Amber, we can't tell you that because we're not the city. So you get to rule. I guess it's your decision, but.
Does anybody have any questions of the appellant's presentation?
I do.
Are you going to not let us ask Amber any
Let the
questions?
city have their, if you're done with your presentation.
I'm not done, but
I will let the city have their presentation.
So you're not,
We're
okay.
going to go in the order in which I,
No, but you're ruling that we can't ask Amber any questions. I just want to clarify that.
correct.
Okay. Then I want to speak to one or two other things in the staff report. In another part of the staff report, it says that the other reason that these 18 permits are not allowed is because it would be going around the 120-day permit requirement. That it would, in essence, allow this applicant to have the signs up for 240 days or 360 days in violation of the purpose and intent of the statute. But that is nowhere to be found either. Let me give you an example. If you have a strip mall with 3 tenants in it, the first one could have a sign that says, everything on sale, and put it out for 120 days. And under this code, the second tenant at the end of that 120 days could say, you know, I'd like a banner. I want 120 days, and I'll just leave up the same banner, everything for sale. It's perfectly legal. The third tenant, the next 120 days, could do it. And if there's a fourth tenant, they could take up the other 5 days, 6 days, depending on if it's a leap year. Although you're asked at the end of this staff report to find a resolution that's improper. In fact, it's perfectly proper. There is nothing in the code that stops it. In fact, it encourages it. Every business is allowed to have a banner for 120 days. And under the code, and under First Amendment rights, and under agreements between the group, the city is not allowed to regulate content of banners. So the idea that a second applicant couldn't put up the same banner, in other words, leave the banner up, is mystifying to me. I don't understand where that's coming from and how that's in your resolution. That isn't a basis because the code allows every business to put up a banner. Second, as far as these 6, since we're not going to be able to question it, but as far as these 6, the second set of 6 that were, 12 were initially denied, 6 were later denied. First of all, it shows that the actions went far beyond ministerial. They went to somebody now reviewing a whole action, and it went days later. That would violate the law by itself. But if we could move past that, in an email from Cliff Jones, I think that's correct, Cliff Jones, he lists the primary buildings per the city, and every one of these 6 buildings is in a primary, every one of the 6 businesses is in one of the primary buildings. Rockwell's, just one example, Rockwell's is right next to or right down from the Nike. Nike has had a valid primary building banner up. Yet that permit was denied. Now what happened, and I don't have the staff report with me, but if you look on the exhibit, they line up, the city, whoever did it lined up the new applicant, the old applicant, because the signs were going to remain the same. Well, as I sent in my memo to you, Rockwell should have been lined up next to Nike, and et cetera, go down the list. And you would have lined up the same buildings. The sleight of hand there was that the lineup was against a different building, not where that new business is located. So on these 6, the city will not tell you they're not in a primary building, if that's the rule. I don't believe it's the rule at all. But 6 of these can't be denied under any interpretation the city will get to. So those are the points I want to make to you. We can respond to the city, but if you're going to rule that we can't ask Amber questions, I would ask you to ask her the following questions. When did the city first come up with this interpretation? And I will tell you, from everything I can tell, it was August 9th, 2016. Why why did Amber come up with that? And I'm sorry for calling you by your first name, but we've known each other for a little while. Why did Ms. Gregg come up with this interpretation? Did somebody suggest it to her? Was it demanded of her? How do we get there? What language was used to get there? Because in the staff report, it just starts with a conclusion. Banners are not, must be on the business's primary structure. That's a conclusion. Neither she nor Mr. Burns in his letter gave us what language they were using and how they got to that conclusion. I know it's not how lawyers normally work. Like I did, I set out the statute and I let you interpret it. I also want to know why we're going past the first sentence. The first sentence tells you on site. If the council didn't want these banners to be limited, they wouldn't have used the word on site. They would have said the banners must be placed in the business's principal building. It didn't do that. It was trying to eliminate railings and fences and fixtures. And unfortunately, I can't give it to you because we just got it at 4:30, but there's a 1991 council directive to find a way of using railings if they fit the right situation to put the banners. But it doesn't change the meaning. It's just an interesting sidelight to it. So we'll come back if we need to. I want to keep it short, and I hope that explains what the statute means. Thank you.
Thank you, Brad. Okay, the city, please make a presentation.
Good evening, Planning Commission. Amber Gregg, City Planner. I'm going to apologize before we get started because I'm slightly under the weather. You can probably tell by my voice right now, but I will do the best I can. So I'm going to run through staff's presentation, which basically follows the staff report and provides additional clarity on a couple of items. But the first is that we're here in order to listen to an appeal application that has been filed by the applicant on 18 banners that were previously submitted to staff. The project site is the outlets, and this is for anyone at home who might not be aware of where we're talking about right now. I know everyone in this room knows where we're talking about, but this is just the project site. And I've put up here the entire request of appeal because I definitely want to make sure that I'm not leaving anything out on the applicant. But it is for 18 banners, 12 that were initially denied and 6 that were denied subsequently that the applicant had previously mentioned, and we'll go more into that in just a minute. So temporary banner permits. I think it's very important that we establish what does the temporary banner permit say in the zoning ordinance. Previously on the slides, we saw a temporary banner permit application, but on the top of that application, you might have noticed that it says here is some of the criteria. So I think it's important that we run through all of what the entire section says. So temporary banner signs shall be allowed for businesses citywide, excluding home occupations. Temporary sign criteria. And then it runs through a number of criteria. But each business shall be permitted a maximum of 1 temporary banner sign per business at any given time. And that temporary banner sign shall not exceed 64 square feet. And that temporary banner sign shall not count towards the business's total sign area. And in the case of the banners before you tonight, none of them exceed the 64 square feet. And I just wanted to make that noted as well. So criteria C says temporary banner sign shall be placed on site and flush on the building. It continues and goes on and says these banners are prohibited in the following locations: city right-of-way, freestanding walls, fences or other fixtures not a part of the business's primary structures, and other locations determined by the city planner to be inconsistent with the intent of this section. No portion of the temporary banner sign shall be freestanding and all corners shall be secured to the building. We agree that all the banners were flush mounted. It's the others that, unfortunately, that the city did not find to be in compliant with this. And that's why the sections are underlined here. And we'll go through that more in detail as we go through here. Temporary banner signs shall be constructed of cloth, canvas, fabric, plastic, or similar durable material. There was a question as to the material of this, but the banners that are out there currently and still fall under this category. And that the temporary banner sign shall be maintained in good condition, free of defects, including cracking, torn material, and faded copy. The last point, and I apologize for how lengthy it is, but each business may have up to 4 banners per calendar year. Renewals of banner permits are allowed, but in no case shall a business display temporary banner for more than 120 days per calendar year. It goes on to talk about minimum distance of 14 days between a permit is required, except upon renewal of an existing banner permit. Banners may be replaced during the authorized period so long as they are the same or smaller in size and installed on the approved location. And then the last sentence is also very important. These provisions are to ensure temporary banner signs are not used as permanent display or in lieu of permanent signs for a business. And that sentence is very important because although there's not a specific intent and purpose in this section of the code, that basically provides the provisions of what that temporary banner purpose is. So what's the history of the temporary banners at Marblehead outlets, or I should say outlets at San Clemente, my apologies. So prior to the subject application that we're going over today, the applicant previously applied and received approvals for 18 of the existing permits that you can still see out there today. The first was for the last 4 months of the 2016 calendar year, from August to December. 4 30-day permits were pulled for those. And then a second set of permits were pulled for January through April. At the end of every year, the permits, everyone gets a shot at 4 more permits again per the zoning ordinance. So on April 28th, 2017, Nancy Mays submitted 18 temporary banner permit applications for the same banners that were previously issued, but she applied for them under different tenants. An example of this would be the guest store. They already pulled all 4 of their temporary banner permits. So the application was for Eddie Bauer to pull a guest store but leave the guest store name. So in essence, the same banner would stay in place but pulled by a different applicant. Since the city can't regulate content, that's perfectly legal as long as it meets the other criteria of the zoning ordinance. So Eddie Bauer could very well pull a sign that said guest and place it on Eddie Bauer's building. However, the temporary banner criteria also requires that the banner be placed on the business's primary structure. In the case of the outlets, it's a very unique type of building. It has several buildings, contiguous buildings, but separate buildings that make up the site. And that is shown here by their site plan. On the applicant's site plan, they identify building 18AA, building 18A, 17A, 19, 20, 21, 22, upper and lower floors. And so we have different buildings identified by the applicant and they are constructed in a manner that makes them contiguous but individual buildings. So that was very important when reviewing that section of the zoning ordinance, and we had to take that into consideration. Here's an example of some of the previous approvals just to kind of highlight what we mean when we say that the city can't regulate content. So this was some of the previously approved banners. This is in building 19, and just to kind of reorient us again, my pointer's not working, but here's 19. And this would be the I-5 freeway back here. This building is the second floor, so I apologize about that, but it would run along here. So in this instance, here's the guest building that pulled the guest sign. Haynes pulled a sign for the Blaze Pizza. Luggage Factory pulled for Starbucks. Bass pulled the sign that said outlets. Skechers for Skechers. Pearl, I'm sorry, I don't know that one, is pulled Levi's, and then Vans pulled for Vans. So we issued these permits regardless of what the content said on it, but we allowed them to pull the banners for the other businesses. So that's what we mean by city can't regulate content. So one thing we have to identify is, what does the definition in the municipal code say? The section 1780.030 provides definitions for a lot of the key terms in the city's zoning ordinance. And in there following is the primary building definition, and it states primary building means a building within which the principal use or principal occupancy of a lot is conducted. And then for primary structure, because the applicant has said this is on a primary structure, it defers you right back to primary building. See the definition of the primary building. So that's what we relied upon, means a building within the principal use or the principal occupancy of the lot which it's conducted. So in the case of the 18 applications, what we did is we said, okay, where is the business located? What building are they located? And what building is the banner going on? And on all the applications, none of the banners were being located on the building in which the business was located that was applying for them. So in your staff report under Exhibit 2, this same chart is in there. And I just want to go over it really quickly. So the business store, this is the name of the business store that was identified to pull the permit. And then this was the location in which that business is located in. So in Building 22, which if you'll remember is, it fronts the freeway as well, but they had asked for a banner that was located on 17A. Well, since that banner isn't located on Building 22, we couldn't grant that permit. And we looked at that for each and every one. So Luxury Mall is in 18A, but they had requested a banner on Building 22. So because it's not on the same building again, we couldn't approve it. In each one, Crocs is in Building 19, but they wanted to place their banner on Building 21. Eddie Bauer's in 21, but they wanted to place their banner on Building 19. Zales is in 18A, but they wanted to place their banner on Building 19. So, and the proposed banner is just to help with reference as you are driving out there, but that is not what was looked at. It's where exactly is the banner located in this context. And I'm happy to go through the rest of the list, but I think you can see what we were looking at and what building we're talking about, but I'm happy to.
Ask questions or? I have one question.
Yeah.
Jockey,
Uh-huh.
for example, one is in Building 20, but wanted to place it on Building 19. I hate to use this as an example because Blaze Pizza is a good pizza, but Blaze Pizza is not on a freeway frontage building.
Yes.
And so why did you put Blaze Pizza in here?
So it's, the reason why Blaze Pizza is on there is because Haynes had originally applied for that. And so it's just a context. So here's Haynes, that's located in Building 19. And because we don't regulate content of the sign, Haynes applied for a banner that happened to state Blaze Pizza. And so they were allowed to put up a banner that identified a business that's not their own because the city cannot regulate what that banner says.
Okay, so Haynes originally applied, even though they weren't in what you consider to be a primary structure or building.
No, Haynes is in the primary, Haynes is located
so
in the
Haynes
primary
is in the
building.
primary building.
Exactly.
Okay, they're in the primary building. And so Blaze Pizza originally applied to take that spot.
No, so in this example, Haynes submitted the application to pull a banner that said Blaze Pizza. Blaze Pizza never made an application.
They never made the application.
No.
Haynes made the application, and so Blaze Pizza put their name on it.
To be perfectly clear, to make this even more confusing, but to be perfectly clear, Nancy May's the one who applied for all the permits. In this case, it was for the Haynes location here, for this suite. This suite pulled a banner that said Blaze Pizza.
Okay. And so then Jockey comes along, and they want to pull a banner where Blaze Pizza had their sign.
Jockey's not on Building 19, though, right?
Okay. I apologize for that, sorry. Forgive me. So yes, it's Haynes, so the application for Haynes, and I apologize if you need to re-ask the question. If I don't answer it correctly, please let me know. But you said Jockey.
Yeah,
Your
Jockey.
question was related to Jockey.
That's on Exhibit
Yeah,
2,
that's
yeah.
the latest application.
So he,
So Jockey made the application for that spot. Okay.
but Jockey's not located.
Jockey's not located at what your definition of a primary structure or building is.
Exactly.
Okay. So, but that's really Haynes's location.
The one that was approved in Haynes location in Building 19 is where Haynes is located. And so, I'm sorry, Celia, you're going to have to come back up. I can't remember exactly.
Haynes.
Okay, thank you. And so they submitted a set of plans that had where they wanted to go on the application as well as where it would go on the building. And so Haynes in Building 19 applied for a permit that said Blaze to be placed on Building 19.
Right.
So that way,
Okay. All right, so that I'm understanding that. So,
okay, good, good.
All right.
Thank you for clarifying that. All right, should I continue?
I think Commissioner Wu has a question.
Yeah, I got a question for Mr. Burns. regarding, seem to be very convoluted. So one applicant in building A applying for a sign saying building B or saying store B on another building. The city says we don't regulate content, but in this instance, taking example of ASICS applying for Nike, ASICS wouldn't have a motivation to advertise for Nike. So do you still consider that a commercial speech that is protected?
I'm hearing the presentation for the first time myself, so I'd like to listen to the conclusion of the presentation and then entertain your question. If you have a question about constitutional speech?
Okay.
Yeah, thank you.
Okay, thank you. So we're getting close to the end. But for the reason that Commissioner Eggleston just stated, that it was a sign in a building, in the Haynes example, you have them applying for a permit that is to be, for a banner that's to be placed on their building. Again, we can't regulate what that sign says. So they were allowed to pull that permit. But in the 18 submitted applications that we have, we were not able to meet criteria 1C, which states that it has to be on the primary structure. And we had to go by what the definitions said in the zoning ordinance. And to get to Mr. Malamute's point, that's how staff got there. We looked at the criteria, looked at our definitions in order to come up to our conclusion. It was noted earlier, but we're happy to note it again, that unfortunately we did make an error and we approved 6 of them initially, but when we realized our error, we did rescind those 6 approvals because, as you saw in the exhibit, none of them were located in the primary building. So those were rescinded as soon as we were made aware of that. So for tonight, we just want to talk about what Planning Commission's role is. There's a lot of information that's been sent to you. There's a lot of information that you're hearing tonight. But at the end of the day, the role of the Planning Commission is to decide whether the Community Development Director's decision to deny this temporary banner permits applications was correct under the San Clemente Municipal Code. And that's the only thing that we're talking about today. Yeah.
Hi, good evening. My name is Matt Silver. I'm an attorney representing staff here today. And I just wanted to briefly address, without belaboring the issue, just a couple points made by counsel for appellant up front on those legal issues. And just to make sure that we have that clear, number one, they didn't raise this here today, but they raised it in their paperwork about they raised issue with the city rescinding, I guess, the 6 permits that the city determined were improperly issued after the fact. I just would like to direct everybody to the municipal code because it does have a section expressly on that issue, and that's section 17.84.010. So it's 17.84.010, subsection E, and then just one more subsection for you. 1, subsection E1 says, any permit or license of any type issued by any department or officer of the city in conflict with the provision of this chapter, which is the sign chapter, is declared null and void. And under the law, permits that are issued in violation of law are called void ab initio, which is just kind of it's just a Latin way of saying they're void from the beginning, because we can't issue permits that the law does not allow us to issue. So this section, 17.84.010 E1, the last sentence, reflects that and says permits that are issued, like these 6 apparently, in violation of the code are void. So that's why that happened. But on to some of their legal points. One of their requests right at the beginning was that the Planning Commission grant their appeal because of an alleged defect in the city's notice. The municipal code provides that the city clerk is to give notice within 10 days after the appeal is received by the city. Here, I'm not sure that occurred. That doesn't appear that occurred. However, a few points on why that is irrelevant and not an issue. One is there simply has been no foul. There's been no harm. They're here today. They obviously know the day. They know the time. Not only do they know the day and they know the time, they knew it with enough advance notice to submit several hundred pages of documents in preparation for this. So there, in the legal world, we call this non-prejudicial error, right? There may have been an error. I'm not necessarily admitting to that because I don't know all the facts. But even to the effect that the city clerk did not give the notice within the 10 days after the appeal was received, they are in fact here. They submitted hundreds of pages of documents. They clearly came prepared and so on. But secondly, the municipal code doesn't provide anything in terms of any support for their argument. Their argument is we shouldn't have to argue any of the substantive facts or the law because the city's alleged failure to issue notice within 10 days after receiving the appeal somehow just declares the whole thing over and their appeal wins without looking at the substance. Neither the municipal code nor the law provide anything to that effect. In fact, the law provides to the contrary. There's a case called Cohen where the city made a whole slew of errors and the court found problem with that. But the municipal code is not that case. There's nothing in the muni code saying, and if the city doesn't provide notice within 10 days, then it's all over, right? It provides that for appellants. It does say for appellants, if you would like to request an appeal, there must be a deadline by which you must request an appeal, and if you don't, then your right to request an appeal is waived. That's extremely common. That's in every city I've ever seen, and I work with many of them throughout the state. I'm sure that the appellants will argue here in a minute, as they have in their paperwork, that if the shoe were on the other foot, that and they applied late for their appeal, then their appeal will be denied. That's pure speculation. I don't know if that's the case or not, but that's what the code says. To the contrary to their argument, the code says absolutely nothing about the appeal must be granted if the notice wasn't provided within 10 days. But in the reality, even if notice wasn't provided within the 10 days after the appeal is received, they've clearly had ample time to prepare a very strong appeal, including hundreds of pages and 2 attorneys being here on this day. I'll note further that we coordinated this day, not unilaterally. Mr. Spock and I had a phone call in which we agreed on this date. We coordinated this date, and I have emails to that effect, which I will in a moment here hand out to everybody so that they have it in the file. But Mr. Spock has indicated to me that notwithstanding our agreement to hold it on this day, that somehow there's still a notification defect. So I would say to the Planning Commission here that to the extent that there was any sort of defect, there really wasn't. There was no error, and the law provides absolutely no support for granting an appeal on that basis. Secondly, they argue that because it's a ministerial permit, that the city couldn't look beyond the contents of the permit application itself. 2 points on that. One, I know that the city staff report references a ministerial permit. Personally, under the law, I take some issue with that. I'm not willing to concede that it is a ministerial permit, notwithstanding that. But that aside, just to have that on the record, just because it's a ministerial permit doesn't mean the city has to turn a blind eye to the municipal code, right? To the contrary, 1C, as we've talked about here, expressly provides criteria we have to check off in order to issue permits. It's not that you submit a piece of paper and we stamp it, and since it's ministerial, game over. The municipal code provides several criteria, right? It must be on site. It must be on the primary structure. It has to be of a certain kind of material. It can only be up a certain amount of time. These are boxes we have to check off. And unfortunately, there was a box the staff couldn't check off, which was that the applicant for the sign was not going on the same building, the same primary structure as the code requires that the applicant's located in. They are, in fact, separate buildings, and the site map shows that clearly by the fact it numbers them as separate buildings. They're not all building 1. There are numerous buildings, right? They are separate buildings. And I'm sure in a moment, and I've got to kind of say in advance because we're not going to get a chance to speak after them, I'm sure in a moment you'll hear, just like their papers, appellants say, well, there is this elaborate system of framing underneath the concrete that binds them all together, and therefore they are in fact one building. Number one, the code does not say that. It just simply is not in the code, and you have to read the code in a distorted manner in order to read it that way, and that's not how the law or code works. Secondly, by that logic, any building on any block, therefore, is all the same buildings because they're connected by plumbing, they're connected by septic, they're connected by all sorts of things. That doesn't make it one building. The reality is there are separate physical buildings out there. They're numbered on the site plan as separate buildings. The municipal code defines a primary structure clearly, and these are separate primary structures. Last but not least, there's an issue raised of selective enforcement. Selective enforcement being, counsel for the appellant has pointed out, or I guess I should say alleged more accurately, that there are all sorts of other signs in the city that have been allowed to exist in violation of the municipal code. The law is very clear that the fact that one speeding driver gets away with speeding doesn't mean that other speeding drivers have a right to get away with that, right? If anybody who's been pulled over by a police officer has never gotten away because they said to the police officer, well, that guy's speeding and that guy's speeding. It doesn't work that way. The city has to start somewhere. But secondly, these other properties in which they allege there are all sorts of sign violations that we've either knowingly allowed or just turned a blind eye to, that's completely unsupported allegation. I don't have any evidence, nor do you, before you, to prove that that is the case. That is simply claims that they've made, and there's been no evidence of that. Secondly, it's absolutely irrelevant to this case. Those are signs regarding some other property that I don't know about, regarding some factual circumstances that we don't know about. Whether they have permits or not, we don't know. Under what circumstances they've been granted or enforced or not, we don't know. All we do know is that the single issue before the Planning Commission today is this very narrow issue, the interpretation of a primary structure. That's it. And whether we interpreted that from a staff perspective correctly or not. Not whether Tommy got a lollipop and I didn't get a lollipop. Not whether another business got to put up a sign or not. That's simply not here today. With that, I'm happy to answer any questions. Otherwise, I think I've talked probably long enough for you.
Commissioner Blackwell.
Yes, I had a quick question on the date of the notices, actual versus required, not per the appellant. What were those dates?
So the date that I sent Mr. Spock, counsel for appellant, an email was 12 days after the city clerk's deadline to provide that notice.
So a total of 22 days?
I think it was a total of 22 days, correct. And Mr. Spock wrote back, thank you. I've confirmed with my client that we're available that date. That was back on May 30th.
Okay. Did the appellant ever state that they didn't have enough time to prepare for this meeting before the letter dated the 19th of this month?
Not that I can recall. Granted, we've been bombed with several hundred pages of stuff, including a mailing that came in the mail to me late this morning from them that was binder clipped. So it could be in there. I apologize. On 4 hours notice, I didn't get to see it, but in too much detail, but I've not otherwise been aware of that. I think the facts show contrary.
Okay. Thank you.
I have a question. Amber, could you put up, I'm going to be asking him the question, but could you put up there again the code, municipal code, where it talks about primary structure? Yes. Okay, it says that they're prohibited in these following locations. And then it says, or other areas or fixtures not part of the business's primary structure. Can you argue that, in fact, because the primary structure says it in that manner, that it is by inference that, in fact, the signs go on their primary structure?
I'm not sure I understand the question. Would you mind
Well,
repeating it?
it doesn't say in there that signs must go on the primary structure. It says not part of the business's primary structure.
I think it's saying the same thing. It's just saying it in the inverse, right? Instead of saying that, I guess instead of saying what you're saying, Commissioner, it simply says it in the inverse. It says instead of requiring that you put it here, it's saying you can't put it here, right? It cannot be in a location that is not the business's primary structure. That is simply the inverse of saying it must be on the business's primary structure, because I think one is kind of a logical conclusion from reading it, but secondly, if it cannot be located on the primary structure or other than a primary structure, then necessarily it must be located on the primary structure of the business. I think that it could there's only two locations where things in any signage world could be, right? On the business's primary structure or somewhere else, right? And the code says it can't be somewhere else. It must be on the primary structure. So I think there's only two options realistically where signs can go: on the primary structure or somewhere else in the world. And our code says it's got to be on the primary structure. It just says that in the inverse. But I get the question. That's where I think appellant
crux of
has kind of attached their argument to, but I don't think that that's an accurate reading, and I would direct the planning commission or refer you to after that semicolon there where it says other locations as determined by the city planner to be inconsistent with the intent of this section. We noted in our staff report was another basis why staff could not issue these permits, because in addition to the argument, even if we just discarded the argument about the primary structure being different than where the applicant and the sign were going to go, right? That's the problem. The other problem is that staff has determined that they're trying to subvert the purpose, intent of the municipal code by putting signs on different buildings. I think they've made clear in their papers that they're trying to advertise certain, I think they call it anchor businesses on the property. And they're trying to use this mechanism to circumvent the 120-day limit to do that, because they've already exhausted their 120-day limit.
All right. I think you've answered that. I do have a question for Amber, if I may.
Okay, please.
Amber, Brad Malamu asked a question, and I'm going to ask you the question.
Okay.
Okay. How did we get there in August? All of a sudden, they came in for an application, and have we ever had this type of situation before where we've had a shopping center like this, where we've had tenants that are not on a road areas for good visibility? So how did we get there? All of a sudden, because you say because of contact. How did this all start? Because this is different.
Yes, we typically don't have 18 banner permits come in one time, but typically what we do have is a banner for a business that comes in, and that business pulls a banner that is located on that business's building. That's typical everyday issuance of a banner. And we follow the criteria and check through it. But that doesn't mean that that's not what we followed in this case either. We have a business. We look to see what does the zoning ordinance say about temporary banner permits, and can we check all the boxes to issue the banner permit. I'm going to let Mary turn that off.
Well, let's wrap it up so we can go back to rebuttal. Keep the time.
Yes, so we followed the same process, but in a much larger quantity. So, you know, it's a lot easier when you have one to look at versus 18, but it doesn't mean that we don't look at this code the same.
Okay, so if Blaze came in, they wanted to put a banner up, we would not, we would permit them to put a banner up on the front of their building, which fronts Vista Hermosa. Is that correct?
That's correct.
Okay. All right, thank you.
Commissioner Wu, last question.
Yeah, I have a question for the attorney, Mr. Silver. Is there any provision about the temporary sign in the development agreement? In the development agreement, the city signed with the predecessor of Untitled San Clemente. Was there any provision about the temporary signs?
Is this on still? Yeah. I'm not aware of that. I'm not aware of a provision for a temporary sign. I would say, maybe perhaps Ms. Gregg can respond to that, but I would say regardless of that, our municipal code simply provides provisions that must be checked off to issue these signs, and they just simply did not meet those. So we can't violate the municipal code, even if there's an agreement to violate the municipal code, that can occur. So I would allege that. And secondly, as far as I understand, this provision has been around for a long time. So it would be, I think, contrary to the code if that were the case.
This provision was adopted in 1995. Can you confirm that? And does it predate the development agreement?
Yes.
Yes, I'm going to say this differently. The development agreement, what the development agreement says, I believe, and Celie can correct me if I'm wrong, is whatever was in place in regards to signs at the time, and this temporary banner permit section was in place at the time of the development agreement adoption.
Okay.
Thank you. With that, I would like to come back and rebut.
Okay. While we're finishing off here, I'm just going to hand out our that email that I was referencing in there. I'm handing 2 copies to opposing counsel and then copies for the Planning Commission. This is simply the email in which Mr. Spock and I, at the end of May, jointly confirmed this date for the hearing. Thank you.
Thank you. I have about a minute, Ms. Burns. Brad may need a few extra minutes, given the amount of time it's been consumed, but I'll just take a minute. I think everything Ms. Gregg said has perfectly isolated the issue down to the meaning, and Commissioner Eggleston, I think you hit the nail right on the head. Fixtures, not part of the business's primary structure, is the clause that the only place that business's primary structure appears. As a matter of simply reading the English language and reading through this, that's the proper instruction. Banners, in the first sentence, notice the first sentence isn't underlined. The temporary banner signs shall be placed on site and flush on bid. That specifies where they are to be placed. And as a simple matter of reading through grammatically, that we know that's correct because of the application form. We know that's correct because there are many ways that this ordinance, this provision 1C, could have said the banner had to go on the business's primary structure if that's where it had to go, and that's not what it says. Thank you. Brad will finish up.
Can you turn off the time? They took 35 minutes. I'm going to need a few minutes to respond to 35 minutes. I took 14 so that I would be able to have some rebuttal time. What was missing from this presentation, surprisingly after I raised it, was exactly what Matt just raised. They didn't discuss why the statute says they shall be placed on site. The city was smart enough to say the city shall be placed on the primary location, the primary structure, if that's what it was restricted to. The second section is a prohibition. And for 25 years, the city's form has said that fixtures, other areas, and fences means fences, trees, shrubs, and railings. The city knows what it says. Amber made an interesting statement that, well, they look at all banners the same. They don't. This is the first time this example, primary structures, has ever been used by the city. We know that. This was made up. Who asked it? I can only speculate, but it wasn't, I suspect it wasn't Amber, but she didn't tell us. Somebody came to the staff and said, stop these signs. And I'm sorry, I want to be that straightforward with you. This has never been used against a single banner in the history of San Clemente. And if it has, I want Amber to get up here and tell us that, okay? I'm sorry, this was a sleight of hand. And here's the other sleight of hand. Amber showed that chart, and Wayne, I'm sorry, can I call you Wayne? Mr. Eggleston? We've known each other 20 years, it's hard. That chart that was shown, can we bring that chart back up? I'm not sure what Nancy did. I haven't seen that chart, and I'm not sure where it came from. But common sense. I don't know how to use the pointer. Did you take it?
It doesn't work.
Well, that's good. Yeah, let me try it this way. Let me try it this way. Rockwell.
You have to use the mic.
Sorry.
So just use the mouse and a pointer.
I'll try it this way. Whoops. Now I lost it. Okay. Rockwell, 22. H&M, 22. If we move that up one line, Amber admits the banner can be there. Why didn't she call Nancy and said, change your chart if that's the problem? Okay, we can do it tomorrow. That'll solve the problem, right, Amber? We have 6 permits then. This is nonsense. I'm sorry. And it's still a misinterpretation. 6 banners, all 6 of these, and it's in my letter. 18A was approved. Look at the right, 18A, Calvin Klein. Luxury, Crocs, 19. 19 is Vans. Eddie Bauer, 21. 21 is Columbia. I could go through all 6. So this isn't enforcing the law the way it's written. This isn't even enforcing it the way it's misinterpreted. Okay? This is punitive. For whatever reason, this is getting back at the applicant. Now, as far as the discussion by the city lawyer, he said, it can't be something else. It can't be somewhere else. But he never, nor did Amber, discuss the crucial sentence here. Sorry, wherever it is, on site. That's the limitation. Primary business, primary structure is not the limitation. The code says it shall be placed on site, and yet not one of them mentioned why on site is listed in the code. Why is on site in there? You have to ask yourself. It's because that's what it says. The banner shall be placed on site. We all admit flush on the building is not an issue. Why is that not in the staff report or discussed by either of these people after we brought it up? Why was it ducked? Why did Amber do exactly what I said the staff report did? She concluded, she starts her analysis with banners restricted to the business's primary structure, but that's nowhere in the code. And if it is, then I ask you, as if you teach your children to read, don't you read words for what they say? The first sentence tells you on site. The second sentence is modifying that, and it tells you in the application, railings, shrubs, and trees. It's not primary business. And as I told you, more importantly, and Amber and the lawyer did not argue, business's primary structure is defined not as it's a building based on the lot, not on the business. Okay? So I'm troubled by that they didn't address all the issues I raised. In fact, they didn't address a single issue I raised. Going back to this, we heard no history of when and if a primary structural limitation actually exists. Everybody deserves consistent treatment. Let me cite you something you all know about, the high school. Does anybody not recognize that the high school has banners on the fences from one end of the school to the other? That's not a primary structure. Does anybody think that's a primary structure? There is no exemption for these banners in the code. In other words, all those banners come under the same rules. I'm not worried about, for the purpose of our discussion, whether this is selective enforcement. Anybody, if they're the city and they're a code enforcement officer, drives by PICO, they would cite those. The city lets those, and they're not only up for 120 days, those are $1,000 and they're up year-round. Why hasn't the city stopped that? There is no exemption for a private charity to be exempt from our city code. Yet, nobody from the city has ever cited them or even asked for a permit application. They're not even paying the $10 every 30 days. We're losing this revenue. I guess we enforce code, but we don't worry about revenue in this town. I'm not sure what's going on. But it's not only selective enforcement, it's non-enforcement if they like who you are, I guess. I guess what I'm asking you for is to decide tonight that words mean something, that the first sentence placed on site has a meaning, okay? And that it's not, the second sentence doesn't say banners shall be placed on the business primary structure. In fact, it says nothing like that. It says it shall not be placed on fences, other areas that are not part. And if they'd wanted to be buildings, it would have said that the banner shall not be placed on fences, other buildings. They didn't do that. They said other areas that are similar to fences and fixtures. They wedged it between those two words. And then the application is consistent. It says fences, railings, shrubs, and trees. The other areas are shrubs and trees. None of which, by the way, which is also another oddity of this section, none of those could be flush mounted on the building. It's odd that that provision's even there, because a fence, another area, and a fixture, you cannot mount a banner to those things flush on the building. So I'm just telling you, this is the most convoluted reading, and I think all we're asking you is to apply common sense. Nobody's asking you to not apply the statute to these banners. We're asking you to apply the statute as written. We just want you to interpret it as it's written. And we want you to interpret that these 6 buildings are primary buildings, and therefore there is simply no way, even under their interpretation, the city's interpretation, that these 6 businesses aren't entitled to banners. There's also nothing, by the way, in the way the city does these applications where you're required to tell them where these sites are, where these banners are going to be placed. And on these banners, it wasn't that clear that's what happened, but I can't speak to that because I didn't study it for tonight. But I think that's it, unless you have any questions. I just ask you to make the simple finding that placing a banner on site is what we've done here. Every banner is on site. And if you find that that's not the law, I'd like somebody to tell me why not. Thank you so much. Sure.
You may.
I think it's pretty obvious why. It may not be to everybody, but could you explain why the applicant has applied for signs for some areas and put them in other areas? Can you just walk us through why didn't the application for the sign be for the place it was intended to go?
In other words, why isn't it the building's location, the business? I believe it or not, I haven't talked to anybody about it, but I think it's fairly obvious. The reason is because these signs face the traffic. The interior buildings, if you've ever walked there, face nobody. A lot of those, if you put a sign there, it would only be the people walking by. That wouldn't be a very effective use of banners. And remember, under this ordinance, every business is limited to 120 days. So they want to use theirs effectively, so they're going to face the traffic, okay? And that's also why primary structure makes no sense, and that was, I was going to get to that, is say there was a building in town, and I can't think of a great example, but say it was in the back. It was hidden, like, let's say it was a kiosk in the back, and it didn't face any street. It's on an alley. Under this interpretation, their banner would be facing nobody. I don't think anybody's arguing they can't put it on the front, on the building that faces the street. I just don't have an example. The only place I can think of is like the Sprouts Plaza and some of these little places, and I don't know where they go. You know, I don't know that. Under the definition in the statute, the kiosk is not the primary building on the lot. It's the main structure. So are they allowed to put it on where they're located, or are they allowed to put it on the Sprouts? The problems you will get into if you approve the definition as made today is every single person that applies, every business that applies, if they're a kiosk, you're gonna have to go through, well, let's see, their primary business isn't seen by anywhere, but we'd like to say it has to be on the primary business. That's reference to a lot, not to the business. That's the other thing that nobody answered. Primary structure is defined not by reference to any business at all. It's defined by of a lot. Nobody, neither lawyer nor Amber, has defined, then how do we get to it has to be in the business's primary structure? Well, we have to then define primary structure. Every business, I will submit to you before you rule, that every business at the outlet mall has the same primary structure, because that's what primary structure says. Business defines, is referencing a defined term, primary structure, which is not related to the business other than what lot they're located on, not what building they're in. So again, go back to the definition of a primary structure in the code, and it says the building, which is the principal building of a lot, not of a business. So the definition that they're posing to you makes no sense, because they want you to believe one definition but not another. Let's believe everyone. We're willing to believe everyone is what it says it is. And a primary structure is not related to a business. Each lot has the same primary structures. Every business has the same primary structures.
Okay, thank you. And if I could just tie the rest of that question in with Amber, I wanted some.
This is the applicant's.
Okay.
Okay, but if you have no more questions, I'm done.
I'm all done.
Commissioner Eggleston, I think, had a question.
I really had a question, not for Brad, but for Amber.
Mr. Wu.
I have a question for Mr. Malamud.
Let's keep it all sorted.
On your complaint filed with the Superior Court, item 41, you said about August 17, 2016, VSC met with the city officials and agreed on a series of points by which the city would accommodate VSC's tenants for temporary signage until the permanent signs were approved. After several follow-up emails, the city agreed to the following in an email dated August 19, 2016. I skipped A through G and then jumped to H. I read it to you. The tenants who apply for a temporary banner sign to be placed on a building must be renting space in the building where the sign is proposed to be located. So you had that agreement with the city. And you're alleging that every building, all the buildings should be considered one building. If that were true, then this item H wouldn't be necessary at all. What was your understanding at the time?
It's a fair question, but I don't think the statement was made. The agreement was a discussion, oral discussion. It wasn't a final agreement. They were trying to render points back and forth. And as far as I know, and I wasn't part of that, that was never concluded. It was a letter saying, let's try to figure out what we agreed to, not that we agreed to this. Now, I may be speaking out of school. I wasn't there, okay? But this was a communication after a meeting. You notice the city didn't raise that issue here because there was no written agreement between the parties. It was a discussion and an ongoing discussion, and apparently now an ongoing litigation and whatever. I think that the outlets certainly don't have to give up rights that are inconsistent with the code, okay? And to the extent that was discussed there, it wasn't a written agreement, and it was a discussion going back and forth. And again, if I'm misstating it, I'm sorry, but that email did go out. There's no doubt about that.
Thank you.
Thank you.
This is your citing out of the appellant's file of motion in court, is that correct?
Well, this is a part of the material. This is the part of the material supplied to us.
Yeah.
Correct.
Yeah.
Very good.
Mr. Chair, could I, before Mr. Malamud sits down, I just want the commission to be clear that your role in interpreting the statute and that sentence is to give meaning and effect to all of the words of the statute, to give it a harmonious reading, and to give meaning and effect to every word if you can. So you do have to deal with what the words mean that says, not on the primary structure. It's prohibited on the primary structure. So it's your job to harmonize all of those words and to try and understand what that section means.
Can I respond to that? There is no words prohibited on the primary structure. So this is where we get into the semantics. That's not what the code says. And more importantly,
Banners are prohibited in the following locations: city right-of-way, freestanding walls, fences, or other areas or fixtures not part of the business's primary structure.
right, there's nothing that says it has to be on the primary structure there. It says fences and fixtures. And you left that out when you talked to the to the planning board. And it was interesting that the other attorney said the starting point is that sentence, the sentence with the prohibition list. No, the starting point in any clear understanding of a code section is where it is allowed, which is on site. And nobody wants to discuss the elephant in the room. If you want to be consistent, why did they include the words on site if they were going to eliminate it in the next sentence? They wouldn't have. They would have said it has to be located on the business's primary structure or in the building the tenant occupies. So if you're going to rationalize and read a clear statute, which I think is absolutely clear on its face, then you do have to be consistent, and there would be no reason to use the words on site if it had no meaning. It has to have a meaning, and it means the entire lot. And so if you find that there's a prohibition, then it's not to on site, it's to the fences, okay, to the fixtures. It's pretty clear. I just don't see how you want to start. You seem to want to start the same place that Mr. Silver wants to start. We're going to start with the prohibition. No, you start with the inclusion, okay? You don't have a penalty before you take off from the line of scrimmage. You have a penalty after you leave the line of scrimmage. Let's realize that we lined up on site. We have the right to be on site, unless there's some penalty, unless they throw a flag. And Mr. Silver wants to say, you started with a penalty, now get out of it. That's not how the football game works, and that's not how it works here either.
Thank you. Okay, Commissioner Michael and Eggleston, briefly, you have another question?
I have of Amber.
Okay.
Brad Malibu brought up the issue of the San Clemente High School. Years ago, I asked the same question. And I want to see if your answer is the same as what I was told 10 years ago. Why are we allowing signs on the fences of the high school?
The reason
And by the way, that's not revenue to the city,
Yeah.
that's revenue to the high school.
Charity, actually, not the high school.
And the reason is because the city has no jurisdiction over school properties. And Adam Atamian is here to answer that, but that's the long and the short of it.
Well, I think we need a thorough answer on that.
Okay.
Because Brad's shaking his head.
True.
So can we get a complete answer on that?
Okay to have Adam come up? Adam Atamian, our code compliance manager.
Good evening, Commissioner Eggleston, Planning Commission, Adam Atamian, Code Compliance Manager. The high school is a public facility and it is regulated under the school district regulations. There is no enforcement action that the city's Code Compliance Division can take or has taken on that property. That is for as long as I've worked here. That is the policy that we've worked under, with the understanding of what our limitations are as regards to that property.
Do we issue building permits there, for example?
I don't believe,
Actually, the state architect issues building permits for school property.
Okay. So we have no control.
We have no jurisdiction over building. We have limited jurisdiction over zoning.
Can I respond to this? Because that's not an accurate statement. Here's the law. As far as the high school is concerned, I'm sorry, I don't know the gentleman, Mr. Tanian, is correct. The city has no jurisdiction over the high school itself. But the law is very clear, and there's plenty of case law out there, that any entity that's not the high school, the city has total jurisdiction over. This is a private charity that's putting these banners up. They are 100% under the auspices. And the cases say that if you're a charter school recognized by the school district, you are not exempt from city zoning. You are required to follow all city zoning laws. This is one step removed from that. This is a private charity. It is fully responsible to follow the city zoning laws and sign laws.
But Brad, the charities don't own the fence.
No, but the charities own the banners, and those banners, remember, just like the
banner's
business,
on the fence, which is owned by the school district.
just,
Discussion here,
okay,
Mr. Eccles.
we can take it up another day, but the banners are what are being cited, not the school district, just like our tenants are, but it's a debate for another day.
Thank you.
We probably should stick to the format of,
That's right.
Yeah.
you know,
All right. So let's-
orderly format, and then the last
Well, I think it was
rebuttal,
important to
and
bring
then
this up,
public hearing.
excuse
Sure.
me, I thought it was important to bring this up because that's an important point, because if in fact people see banners on fences and it's a school property, we need to know that. Whether it's outside of the limits of what we're talking about right now or not, this was brought up, and I think it's very important and relevant to talk about it.
Thank you. Okay, last question here before we go into the public hearing. Mr. Blackwell?
No, I'm
Then we're done.
Okay. Okay, so getting back to the temporary sign permit language in its entirety, the most important, as stated by Mr. Silver, the most important piece of this here is the portion that reads, other locations as determined by the city planner to be inconsistent with the intent of this section. Can you walk us through the purpose and intent of that piece of it and the interpretation? Just walk us through your interpretation as city planner and how it applies here.
So I'm going to walk you through the whole banner permit again, okay? So again, there's more than just this one. I'd hate to say that that's the most important one, right? Because if it didn't comply with something else, let's say it was larger than 64 square feet, then that might be the most important one. But for the purposes today, you know, we do look at each individual criteria, so we can check that box to see if it complies with it or not. And in this case, we do read it in its entirety. We take the first sentence, but we don't stop there. You have to continue reading through, which is what we did. The temporary banner sign shall be placed on site and flush on the building. So when you read that, the and flush on the building, there's an assumption that the on-site is the building. And that's clarified further in the sentence where it says it's prohibited on other areas or fixtures not a part of this business. Primary structure, and that's where we go to the definitions. So in both of those cases, you know, it's stating without being very blunt about it that it's the primary structure. It's inferring it, and that's how we got to the definition section. And I wanted to bring up the definition because I think it's very important. So the primary building means a building within which the principal use or principal occupancy of a lot is conducted. It means a building. So that's what primary building is. And then primary structure, we did go to primary structure thinking that there would be more, but in the definition, it clearly defers you right back to primary building. So that's how we got there, was simply by reading the text and connecting the dots.
Okay.
So we don't want signs where they're not supposed to be.
Well, yeah, you know, and as in the last sentence that we were discussing also, and I hate to jump back and forth, these provisions are to ensure temporary banner signs are not used as permanent display or in lieu of permanent signs for the business. You know, that's all in there too, and we're not saying that, you know, that's part of what we review also. But, you know, with all the other information, we didn't feel that it met that criteria.
Okay, and my final piece of this is, we have a freeway sign ordinance.
We do.
Can we talk about how that might apply or affect this?
It does not.
That's not.
Okay. I have, thank you.
Thank you. I think we've probably provided due process tonight. We've gone a little, you know, a little more rebuttal, but I think the appellant should be pleased with his ability to speak and bring things up along with staff and the other support. With that, we will close that part of the briefing and go to public comment. The first speaker tonight is Richard Metcalf, followed by Karen Ahola.
Good evening, gentlemen. I'm Colonel Retired Richard Metcalf. I live in Bella Vista, part of Rancho San Clemente. I've been there for 14 years. I think the core issue for me and a lot of my constituents in our community is that progressively we see the outlet mall, or at least the back side of the outlet mall, looking more and more like the Barnum and Bailey Circus Midway, now defunct Barnum and Bailey Circus. And I just heard something here that the freeway sign ordinances do not apply in this case. But I see this effort on the part of the outlet mall to circumvent that with a bunch of cheap-looking signs that are out there, and who knows what temporary means as far as how long they're there. And just as a resident of San Clemente, I'd like to see us keep a relatively pristine look to our community. We're going to have enough trouble dealing with the toll road. This is trivial compared to that, but they both have to be dealt with. And I think they've tried to slide one under the door here. Thank you.
Thank you. Next speaker is Karen Ahola, followed by Mr. Steve Craig. We only have these 3 cards. Okay.
Good evening, my name's Karen Ahola and I am a San Clemente resident. And I would like to ask that the Planning Commission uphold the staff's finding to deny the temporary banner permit, as their findings are legally correct. Additionally, I just heard something mentioned earlier on by Amber, and it referenced that the language in the signage code states that the intent of temporary banners should not be used in lieu of permanent signage. But it would seem to me, as a San Clemente resident, that this is expressly the intent of the applicant, and therefore perhaps all temporary banners at the outlet mall are actually in violation of city codes per se. I respectfully request that the developer be given no further latitude to undermine the integrity of our city's codes and ordinances, which are in place to protect every San Clemente resident's quality of life equally. Currently, the applicant's actions with the temporary banners being permanently there, it flouts the spirit of the law, it flouts the law itself, it undermines the legitimacy of our signage codes, and it makes a mockery of our rules and regulations. And I think it's ironic that the applicant's lawyer said never in 25 years have we had to deal with something like this, and I probably think that the lawyer's correct. We probably haven't, unfortunately. And finally, as a San Clemente resident, I'd just like to say that I think it is a disgraceful waste of taxpayers' money that we have to defend and deal with this applicant's ruses like this. It's happened before. It will no doubt happen again. And it doesn't sit well with many San Clemente residents, and I can say that on their behalf. Thank you very much.
Thank you. Mr. Steve Craig.
Good evening, Commissioners. I'm Steve Craig, and the Managing Partners of Outlets of San Clemente. And I just actually have a couple comments tonight. I do want to take exception to Mr. Silver's comment with respect to selective enforcement. I think it's the biggest issue that you probably have. As was well pointed out by Brad, and at least one of the circumstances, and I've actually witnessed what a lot of this ordinance was written about. There's a place not too far from our office building where someone ties a banner between 2 trees. Every night, every day, they tie it up and they take it down at night. It's been that way for years. That's an example of, I believe, what they're trying to prohibit. The reality is we've done them in as tastefully as manner possible and tried to be as professional as we possibly could in putting them up there. My second point is having to do with the concept of what you read in the ordinance as to on-site, because it wasn't clear to me that anyone raised the issue, but really the opposite of on-site is off-site. And the reason I believe they're using the word on-site is because any sign that's not on-site is actually not even regulated by your city. It's primarily a state issue. Off-site signage is defined as billboards. So I believe they were accurately using the word on-site, and I believe that we are doing that. And with respect to the spirit of the law, we're putting signage on buildings. The issue is some of our tenants aren't all in the exact same spot. So we're trying to manage a process within the context of the number of tenants that we have. Lastly, and I believe it was brought up by one of the commissioners tonight, there is a development agreement. And one of the things that was left out, both on our presentation and I believe comments from the city staff, is that we have a development agreement that specifically allows for freeway-oriented signage. And we submitted an application well over a year ago for that signage. We've actually been submitting applications for a long period of time, but we've been thwarted by different residents who aren't in favor of freeway signage. But the fact remains is we have a legal binding document that approves signage on the freeway, and that was the reason why we located the center here. We would not have located it here had we not had signage. There simply is no way for people to know that we would be there, contrary to all the theories of the internet and everything else. So I would ask that the city, in the spirit of that, live up to their obligation to provide freeway signage while we're going through the application process with EIR, which has been delayed, and I think even your development manager would tell you that they were responsible for a good portion of the delay getting that process completed. With that, I respectfully request that you uphold our request and look forward to seeing you sometime in the near future. Thank you.
Okay. We have some additional cards here. Mr. Richard Boyer, followed by Mr. Steve Knobloch.
Hello, Planning Commissioners. I don't envy you this job, and I regret the incivility that was once again being visited on this body by people with a particular goal in mind that does not serve the residents of San Clemente well. I'm not really sure where to start, so it seems to me that maybe a discussion of roles would be worthwhile. And you might think it's a surprise for me to say I think it's admirable that the applicant is showing the tenacity that he is. That's a good businessman looking for every advantage. I'd also like to commend city staff for identifying an error and correcting it. That's the ethically correct thing to do. And for the Planning Commission, thank you, first of all, for sitting and having all these, suffering the slings and arrows of this process. What your role is, which the Planning Commission did a fine job of in 2006, when they recommended a single project identification sign for a freeway-oriented sign, that was the correct answer. And it was the city's sign consultant, the design review subcommittee, city staff, and planning commission were all unanimous in agreeing on that. And it was only under pressure from the applicant that 3 members of the city council collapsed. They buckled under the pressure and awarded signs far in excess of the previous 2 attempts. The first one, which was denied by the city because it was before any permits had been issued. The second one, which the city also denied, the freeway-oriented signs. The third one, we went, I'm the president of the citizens group that took the city to court. We prevailed 3 times. We collected fees and costs in the amount of $114,000, and the total cost to the city was around $250,000. And at the recent scoping meeting, a number of people from, that was 10 years ago, showed up, remembered that. There were some of our supporters. They said, didn't we settle this 10 years ago? That was the 3rd time. And we got fees and costs because the judge found that we vindicated an important right and we provided substantial benefit to the public. And I think right there, that is a key phrase. That really resonates with me. And I'll wrap up by saying the benefit to the public suggests what was awarded to the applicant was something else. And the benefit to the public that the lawsuit provided was, in a way, a remedy to bad behavior on the part of somebody
Okay, thank you very much.
in the city that should have been doing something else. Thank you.
Now, Mr. Steve Knobloch.
Good evening, Commissioners. Steve Knobloch, resident of San Clemente. I'd just like to comment on some of the discussion tonight about the language in the ordinance and the reference to on-site. The ordinance is clear. Temporary banners are allowed by businesses to be placed on-site. What does that mean? The city has had a lot of discussion on the buildings, as though they're separate buildings on separate parcels owned by separate people. This project is not multiple buildings creating a project. This is a single unified project. It's connected not by plumbing underneath the ground as residences are, electrical wires. It's connected by a...
Hold down the top.
It's
There's some talking in the background that's interrupting you, so thank you.
The project is one project owned by a single owner. It's a single legal lot, a single street address, and a unified structure held together with a superstructure. The buildings appear to be different buildings because they're labeled buildings, but they're not separate buildings. There's nothing separate about them. The buildings are unified, they're built. You could make this building look like 15 different buildings and call it 15 different buildings by the architectural detail that this structure has, which was required by the city and looks beautiful. It's received awards statewide for its architecture and probably will continue to. So when we talk about on-site, every business in the outlets, and there's many businesses, dozens and dozens of them, and there are going to be a whole lot more. They're all entitled to temporary banners. But to focus on a primary structure, this is the primary structure. This isn't building A, building C, building D. This is the outlets of San Clemente. All the buildings, it looks like many buildings, but it's really not. Regarding the comment that, the appropriate comment that Commissioner Wu mentioned about the waiving of the rights and the agreement or the discussion of how this would all work. The agreement wasn't ever intended to be a waiver of the outlet's rights. There was a discussion about what was allowed. A careful reading of the statute allows us to do what we're doing, and hopefully the Commission will agree. But those rights weren't waived. Nor are rights waived when the city violates its 10-day rule by waiting 22 days to give notice and say, well, you're here, you showed up, you produced a thick number of documents, it must be okay. It's not okay. The city requires people to obey the rules. We're obeying the rules. In fact, that's why it's taken so long to complete the EIR, because at every turn the city makes additional requests and we try to meet them. We follow the law explicitly, and we expect and hope that the city does as well. So what I'd like to ask, my closing comment, is that the city the city commissioners, you gentlemen, put on your hat and ignore the vitriol that you hear about signs and not liking signs and how terrible they are for the community. They're important, they're crucial for every business in this town, for every business in this country. We ask that you put on your hats of logic, representing the constitutional rights of the citizens of San Clemente. Thank you for your time.
Thank you. Okay, we've been going for an hour and 45 minutes. I'd like to go to recess for about 10 minutes. Commissioners, before we go into discussion, we're going to close the public comment and are cautioned about any discussion. We'll reconvene at 7:45, about 7 minutes from now.
get them like in a store?
Excuse us, please, we're back in session. Commissioner Eggleston?
Going back, just cruise the window down, he parked, and it's jumping up and down.
As a reminder here, we've had discussion presentations from both sides, including the appellant and the city. I think sufficient due process has been provided. We've had public input. I'd like to remind the commission to go into discussion here. This is an administrative process. Excuse me. We're here to discuss the ordinance as brought forth by staff and also by the appellant. And so we need to keep within the confines of what we're here to do tonight. It's very, very bounded and very strictly fenced off. And if we start straying from that, I've asked the city attorney to step in.
Thank you.
When required. With that, we'll start discussion. I think Mr. Crandall has his light on.
And I would just ask all the commissioners to not bring any new facts in your discussion. Just deal with what you've been presented with and your own analysis of the words, and don't ask nobody bring in an additional fact that opens up a hearing and causes a problem with the due process.
Okay.
Thank you.
Now is not the time to go into discovery, so to speak, as that portion is over. We have to deal with the facts as presented. Commissioner Crandall.
Okay. Since I haven't spoken yet tonight, we'll kind of go through this. Being an architect, I've dealt with ordinances and codes and realize sometimes they are not worded the best that they could be, but you can get the general sense of them and know how they apply to projects. So going through this, I don't want to make any comment on the ministerial or noticing motions that were requested. I don't have enough information on that, so that's not part of our discussion tonight. Temporary banner sign criteria. And we have A through, I think it was F or whatever, and everybody's said what things mean and what not, and I'll tell you what I think they mean. I won't make a conclusion because it's just for discussion purposes. Each business shall be permitted a maximum of one temporary banner sign per business at a given time. I don't think anybody questions that, and we're talking about banners in general. Then we go to the temporary banner sign, which is the business's temporary banner sign. So I read that as the business's temporary banner sign cannot exceed 64 square feet. Then it goes to general terms. A temporary banner shall not count towards a business's total sign area allowance. Back again, we're to the temporary banner. The business's temporary banner sign shall be placed on site. And everybody's definition so far seems like they're saying placed on with no hyphen site. And that's not the interpretation I get from that, which is not a noun. It's not describing the lot. And the zoning ordinance does not have a definition for it. If you go to Merriam-Webster online, it defines on-site as at a particular place, especially of business. It's not talking about the entire lot, it's talking about a place of business. And it goes on to even say for English language learners, which I still am, at the place where a business or activity happens. That's on-site. Like you are providing printing on-site. That means it's at the business, not on the site somewhere. It's at the business. So that, I don't know why we didn't study more about, or why the word on-site was not brought up earlier. So on-site and flush with the building, good. These banners are prohibited in the following locations: city right-of-way, freestanding walls, fences, or other areas or fixtures not part of the business's primary structure. And everybody's kind of keyed on that. And in the building code, there's all sorts of ways to interpret what a building is, or a structure. In the zoning code, we have a definition, And why do we have addition of something for a primary structure is strictly so you can identify an accessory building. If you don't have a primary structure, you don't have an accessory building. And everybody's saying that, what does primary structure? I think they're actually stretching and doing as if there isn't a definition for it, but there is a definition. So my interpretation is we have multiple primary structures on the site. Each one could have accessory buildings, and that's why it's called a primary building. But I don't think, and the way I'm interpreting it, it doesn't go into enough detail saying that the one building that contains 19, 21, 22, and 17A, I can see how a common sense person would say that maybe that's one building rather than multiple buildings that are attached. I'm not convinced one way or the other yet on that. But once again, this is following the appellate's thing. Words do mean something, and we're going at this with common sense. So my interpretation at this point is that we have multiple primary buildings because they have the correct occupancy. They are separated by a distance. We don't have a definition of it. The building code is not a reference for what is a building or not at this point. So we have to make our own determination or use the dictionary. And a building is a roof and walls. Doesn't talk about foundation, doesn't talk about floor area. The zoning ordinance talks about, building lot coverage. That would be the whole building, the whole attached building. It wouldn't be each individual unit. So I think it can be interpreted both ways, as the separate buildings or the primary building. And the whole reason for using the word structure is there are all sorts of things that can be attached to the building which are also accessory structures. It doesn't say, but I think it was intentional that they used structure rather than building, because structures can include attached walls, fin walls, attached walls. They specifically itemize out freestanding walls and fences. If they were attached to the building, the next sentence would cover it. Because it would be part of the business's primary structure then. So just wordsmithing this, I don't think we have any critical items as far as the dates and whose sign they are. I think it's very clear that who applies for the banner is a business, and everybody in this complex is allowed to have a temporary sign up to 4 times a year. And I think when we look at on-site, to me, on-site means at the business location, not on the entire property, because the definitions that I saw do not include lot or property. Because it's being used as one of your attorneys, raise your hand, it's either an adverb or an adjective, not as a noun, stating the property itself, or the lot itself, excuse me. So that is the direction I'm leaning at this time, and I want to hear everybody's comments. And so if a business applies, what is on that sign is of no consequence. I don't think it matters as far as what we're doing here tonight, but looking at the applications, it it doesn't appear that, now let me reword that. The application should be by a business that's in a building who wants a sign. It complicated things seeing whose name was going to be on it. It probably didn't need to be in the staff report, but it is, and that's fine, because it was on the application, I believe. And where it's located could be construed as it's a code enforcement issue, but I think we know that that's a difficult way to do it. So making sure that it's on the the building that the business is in meets the on-site definition, and that's the way I'm leaning at the moment.
Mr. Wu.
Thank you. In the municipal code 17.84.030.h, there are six criteria starting from A through F. There was no discussion and no dispute about A, B, then D and E, so I would skip those and focus on the two items. I started with F, which is about a time limit. At the end of it, the provision, it says those provisions, meaning the time limits, are to ensure temporary banner signs are not used as a permanent display or in lieu of permanent signs for the business. My interpretation is that the city should have never allowed a business to apply for a different business on a different building. It's just not the natural way, and it doesn't, it's not an understanding that should be arrived by people with common sense, in my viewpoint. Because if it, we have to presume that when the city council passed this legislation, passed this ordinance, they meant it to be internally consistent. If we allow a business to apply for a different business in a different building, that will lead to absurdity. The absurdity is someone can circumvent and put a temporary banner signs on a building year-round. That cannot be the intent of this ordinance. By that time, I have to guess the city council wouldn't anticipate a situation that we are facing today. So that's my interpretation on the F. But unless this interpretation leads to a violation of the commercial speech right protected by the Constitution, otherwise I think it should be applied. And then we go to C. The temporary banner sign shall be placed on site and flushed on the building. The ordinance doesn't stop here, apparently, because yes, you have to be on site, but you also have to meet all the other criteria from A through F. So we'll continue on that. It says these banners are prohibited in the following locations: city right-of-way, freestanding walls, fence, or other areas or fixture not part of the business's primary structure. Other locations determined by the city planner to be inconsistent with the intent of this section. No portion of the temporary banner sign shall be free-hanging, and all corners of the banner shall be secured to the building. My understanding is, or my interpretation to this clause is that the signs are limited to a primary structure. The primary structure is the primary building. They are interchangeable, and it's described in the definition of the municipal code. What is a building? I'm also an architect. A building is a structure that accommodates people's activities. A structure is something, a structure doesn't have to be a building. A bridge can be a structure, a gate can be a structure, but a building is something that, a structure that accommodates people's use. So by looking at the real thing on the site, I would say the building, it doesn't matter how we label them, but the building 19, 21, and 22, I see them as one building because they're continuous building massing. There's no separation between these three, if we call them buildings to this moment, but they're all continuous massing. And they even, if you look from the air or if you look from the street view, they're just one long building with looks like an L shape. Regarding building 17A, I would consider that as substantially connected to the building I just described. Building 19, 21, and 22. The reason is being the connection is made by a substantial portion. There's a function inside that connection. There's a second floor, and if you look at the site plan, the connection is about half or little bit over half of the gap, and the building height is taller than the rest of the building. So I would consider that 17A is also part of the same building. But the building 20 is a standalone building. A building is a standalone building. Much of the temporary sign ordinance is based on the public interest about aesthetics. So it doesn't matter how you are connected underneath. If you have the same foundation, especially if you don't have a basement, it's just a slab of foundation, it really doesn't matter. For a person standing on the street, they are different building. They're standalone building. So building 20 is a different building from the long linear building, in my interpretation. Building 1, it's hard to say. Building 1 is connected to building 20, but the connection is pretty weak. There's just archway. But building 1 is not in our analysis here, so I will skip that. I consider building 1 a separate building with building 20, but it doesn't matter today. Building 18A and building 18AA has the potential to be one building, just like building 20. Only after if you build the phase 2 to connect them, as of today, they are two standalone structures. They are two standalone buildings. So that's my interpretation of the code. Thank you.
Commissioner Blackwell.
So I would agree with Commissioner Wu's statement about the separate buildings. I think our building official could likely or easily attest to that it's more like 5 separate buildings. And here with this situation, I think one thing is very obvious, that there's been, in my opinion, abuse of a code provision here. And what I mean by that is that we're talking about a temporary sign banner permit section here. We're talking about it left and right, up and down. But the intent of it in its entirety really is to address temporary signage. And when temporary signage is no longer behaving temporarily, it becomes permanent. So now we're talking about permanent signage in a way. And I would be interested to know if there's any sort of statute that would protect against that sort of an abuse, but that's not something to get into at this point. The intent of the ordinance, Section C, in its entirety clearly is meant to reduce a proliferation of signage where they're not needed. We don't need signs, too many signs on a building. I think it's very clear here that is not what the applicant is intending to do or has done. So for those reasons, I'm not comfortable with the situation at hand, and I am comfortable with staff's report and recommended direction.
Mr. Eggleston.
We've asked to approach this with common sense and harmonious manner and to read all the words. And I think that's important to do. We can't just pick out one word. We have to take a look at this entire paragraph here and also the definitions of it. The temporary banner sign, I'm going to read this sign. I know we've read it over and over again, but I'm going to read it again. The temporary banner sign shall be placed on site and flush on the building. It does not say the temporary banner sign shall be placed on site and flush on the buildings, plural. So that to me means, since it's singular, that in fact, on site does not mean the entire development. It means on site of where the building is located. These banners are prohibited in the following locations: city right-of-way, freestanding walls, fences. And then we come to something that's really important. It says, or other areas or fixtures not part of the business's primary structure. It does not say not part of the total of the center's primary structure. It says the business's primary structure. So that narrows it down to me where it should be placed. And something very important, it says other locations as determined by the city planner to be inconsistent with the intent of this section. So that gives some leeway there for the city planner to determine what is inconsistent with this section. I think it's important to understand here that while the center has separate buildings, we have buildings 17A, 19, 21, 22, Building 1, Building 20, 18A, and 18AA. And 21 and 22 are connected, but the other buildings are physically separate from the drawing that I see here. So to me, each building is a primary structure or a primary building. And going back, I think I have to use the most widely accepted definition of what a building and structure is. When you talk about structure according to Webster's dictionary, it talks about manner of building. When you go to building, it talks about anything that is a built or a structure. So they're used interchangeably here. So I have to go to the most widely used definition of what a building and structure is. But I think the city is correct. I find it difficult to understand, but I think the city is correct that in fact a tenant that is on building 1, for example, should be able to have a sign on building 19 or 17A or 21 or 22 because content is important. You cannot regulate content. So you have to allow, and the city has done this, to allow signs that are not freeway facing to be on buildings that are freeway facing because we cannot define content. So on one hand, it says it has to be in the primary structure, but on the other hand, it says that we can't define content. So it's important to understand both in order to come up with a common sense approach here with this. Could I get the definitions of building and primary building means a building within which a principal use or principal occupancy of a lot is conducted. Primary structure, see definition of building primary. So I think that it's important to understand that the city really has taken a view here that they have to allow for content on the buildings of 17A, 19, 21, and 22 because we have, even those, these are not the primary structures of those buildings, and like in number 1, we have to go by content also and allow content.
Cannot. Say that again? What?
The buildings, for example, a tenant in building 1 is not, that's their primary structure, right? But we have to allow, because of content, their sign on 17A, 19, 21, or 22.
I don't get that. I don't understand that.
Because that's what they're doing right now. We have to allow that. We can't say that they cannot have a sign on those buildings.
So your position is that they can have a sign on any of the buildings on the site then? Or, because building 1, in my interpretation, would be, that's the building they can have their signs on.
Well,
Because they're the applicant for the sign permit.
the
Yeah.
Building 1, tenants in Building 1 currently have signs on other than their primary structure.
But that's because an applicant from building.
That's because an applicant on those buildings
Correct.
has
Applied for a
allowed
sign.
that.
Applied for a sign of
And
which.
they've applied, they're the ones that have been the applicant
Correct.
for those people.
And that's allowed, and we.
And
put
that's
out
allowed
everything
because of the content.
Allows what's on the wall.
And that's allowed because of the content. Is that more explanation of it?
My interpretation is that what you're saying is Building 17A, it's his sign.
And he's
We
making,
happen to put the text on for Building 1, but that's irrelevant.
right,
That's correct.
It means nothing.
right.
So this, it's not Building 1's sign.
No, it's not. It's Building 17A's sign, of which the content of the sign is for another building.
But that's not.
I think it's probably, for me, it was easier to take these signs and say grand opening or half-off sale, and not worry about whose logo or something's on it. Just consider the sign that 17A took out as being a 50% off sale sign.
Right.
And then.
It could be
building-
any sign.
It can.
It can be any
So
sign.
therefore, Building 1 has nothing to do with it. They don't even come into the equation.
Right. Well, it could be any sign. Any sign.
Absolutely.
It could be any sign on Building 17A. And whether that sign is for grand opening, or a sale, or for someone else's logo, that's permissible. That's permissible
By the business in that.
by the business
In that building.
in that particular building, right?
Agreed.
Okay, okay, I just want to, maybe I didn't explain it
Wanna
correctly
make
there,
su-
but,
Well, we both want to make sure
Right.
we're all on the same sheet of music.
No, I know,
The way
that's-
you said it was a little confusing.
okay. I just want to be sure that
Agreed.
because of content, we cannot prohibit what that sign is going to say.
Absolutely.
And that is important, very important out there. So the city has allowed that. Okay. Because, I don't want to get any more confusing, because, for example, Blaze Pizza, who's in Building 1, did not make the application. Haynes made the application to allow Blaze Pizza, the name Blaze Pizza on their sign. Is that correct? Okay.
That's in the report.
Hmm?
That's correct, that's in the report.
Okay, so
That's where it is.
and that's what I want to be very specific about. I know it's confusing out there. It is. And when I first heard about this, I thought, well, why are they doing that? It is because of content
They're allowed.
that they're allowed to do that. That Haynes is allowed to have that type of signage on their building. Correct?
Correct. We have to consider these content neutral.
Right. It's content neutral.
We're
Okay.
all about an agreement there.
Pardon me?
I think we're all very much in agreement on that.
Okay, just to be sure, just to be sure. Now, that was all very confusing, and I'm sure it's very confusing to the people listening to this on television, but that's what it is. Whether, we have to agree with that content or not, we really have to agree with the content, because that's what, I guess, the law says, that we have to agree with something of that nature. So we have to go by what is correct. So, we have to look at this as a whole, not one word, but in a harmonious fashion with all the definitions there. And I know that Some would like to do just one word or 2 words, but that's not what we're here for. We're looking for the whole shebang here. Okay?
Mr. Blackwell?
Just for clarification, Building 1 isn't actually where Blaze Pizza is. That building is not even shown on this exhibit, correct? Okay. And that's on a separate parcel. So all the buildings on this parcel, all the buildings shown here are on one parcel. Is that correct? Okay. Just to be clear. So we've got Blaze Pizza signage on its building, is it 19, or one of the outer buildings, from another parcel completely, different parcel. Just
No, they're all one parcel.
even the Blaze Pizza is one
It's all
parcel?
one parcel.
Okay.
Yeah.
The last speaker said
Enough.
it was 2 lots.
Okay.
Okay.
But just for clarification's sake. Yeah,
Okay.
thank you.
Are you ready?
You go ahead.
Okay. Once again, this is a very complicated issue, but then again, we have to boil it down to maximizing the constants and minimizing the variables. I think during the various hearings by both parties in this, both have echoed the common sense approach or read the words. I tend to boil it down to very simple reading of the ordinance in its entirety, which is the intent to limit temporary signs, to make sure that there's some structure to the process, that I think the primary building versus primary structure, I also went to Merriam-Webster. I think that's pretty common used dictionary for terms. I think 3 or 4 of the commissioners independently went to that dictionary. There's many variations of it, but where structure and building are somewhat interchangeable. And so I can find that that particular definition is consistent with that. Within the focus of this code, it's looking at some other cities in the local area, it's also consistent. So I'm comfortable with the staff presentation of this. The issue of the signs in the buildings, it was a unique approach by this owner to try to, make his building a success. But in general, when you look at the total entity of the ordinance in its entirety, in its common sense reading of it, the intention there was temporary signage, a certain amount of time, and 20 years after it was written, or 25 years now, we can get all balled up in the what's the intent or meaning of each word, where it's fairly simple that the object of this was temporary signage over a certain period of time, over certain structures, by certain businesses. I'm just going to boil it down to something very simple as that. And so in that perspective, I understand the issue of a very good tenant here and a long-withstanding person that's tried to bring this project alive. But within the structure we've been asked to look at, I'm going to support the staff report.
Okay.
Commissioner Wu, you have something you want to say?
Yeah, it appears that, let me just clarify that. It appears that we have sort of a consensus. I want to rephrase that to see if you agree with. So the understanding is that any building on a perimeter, let's say building 17A, 19, 21, and 22, inside those buildings there are about plus minus 20 businesses, 20 stores. Those 20 stores can be the applicant of any signs for any business on the site. In other words, if building 20, a business wants to put a sign to be visible by the freeway driver, and the applicant needs to be one of those 20 business.
Correct. That's correct.
In the building on the perimeter.
Correct.
Okay. And
The
so,
building they are in.
so technically, for the application denied, the applicant can technically swap out some of the, just change the applicant's name, and they can get them.
Only, only if it's within the same building over the period of time allowed by the ordinance.
That's right. That's right.
This,
I wonder if it wouldn't be better to just focus on primary structure and the staff's interpretation of that, as opposed to getting into how it applies. I mean, certainly, you want to look at how it might apply to look at the entire code and how the whole system works. That's certainly appropriate. But I think the matter before you is the staff's interpretation of primary structure, and whether you're going to
That's correct.
uphold that or whether you're going to find that that was an error. And I think if you start getting too far adrift of that, we're going to have a very confusing decision, and we're not going to be sure if you upheld it or didn't uphold it. So that would be my recommendation, and maybe I'm wrong about that, but that's the way I see it being most helpful.
No, I think you're right, but it's important to, because we're going to be questioned, the community out there is going to be asking, well, why can someone in the interior have identification on the outside? And that's really one of the cruxes of this in order to explain that, but I agree with you. The definition of primary structure here is the crucial criteria.
that's what we've been asked to rule on.
That's what we've been asked to rule on.
So for that matter, I would support the staff interpretation about the primary structure. But is it relevant or important for us to decide whether building 19, 21, 22, they're one building or separate building? Is that relevant here?
Absolutely. That's probably the biggest question we have tonight.
That's right.
It could be, do we have somebody, I mean, we've all looked at, if I may, we've all looked at Webster's definition. Can we ask that somebody, official staff member, get up and tell us, based on the building permits that were issued, meters, whatever it is, standalone, separate walls, how many buildings are on this property? I think it's definitely more than one, for sure. And it's probably more like 6.
And
I think
I again caution the commission against
We're beyond staff input.
bringing
We're
up
in discussion.
more
Yeah, we're
facts,
bringing up-
otherwise you
So
open
we're-
the public hearing back up.
We're in discussion, staff and input is over.
Okay.
It's
Right.
us to figure it out.
Yeah,
So,
And so, go ahead, Mr. Moore.
I'd like to just jump in real quick. It's, the zoning ordinance looks sometimes at things differently than the building code. So I wouldn't rely on building code. It becomes very complex and whatnot, what a building is and not. So we have to look at it as a zoning ordinance. And as I'm very confident, Jen and I at this point agree that 17, 19, 21, 22 could be considered one building. That's one interpretation. It could be separate buildings. The most lenient would be to say it's all one building. That's not how staff has currently interpreted it with the permits. And if we take the position that those buildings are one, then it was said 6 permits, but I see 4 applications. Rockwell's, Crocs, Eddie Bowers, and Crossover Health would comply.
If they had. With regard to the 120 days, though, that's the important, that's the important criteria.
That's why I say they would comply with our interpretation of what the buildings are. As far as duration, that's something I don't have at the tip of my tongue on those applications. And that would be the most lenient interpretation. If we say they are single buildings within that big one, that's how I believe staff interpreted it when they reviewed the applications.
And I think, Mr. Chairman, if you were to either uphold the staff, then the staff knows what your action was. But if you were to say, based on a couple of comments, that you disagree with staff and you believe certain buildings are primary buildings, that was a different version than what staff did, then what you would do is find that, and that's what's before you, and then you'd be remanding it back to staff to tell them, figure it out now. Now we've told you what the primary buildings are. Now you figure out who gets a permit and for what period of
So for
time.
the dates and all, we could leave that up to staff.
So let's get our hands around this. We're pretty comfortable with defining whether a primary structure and the building, the basic terminology that the staff asked us. We support that. Now the question becomes, is building 17A and 19 a different building? Or 21 is different than 19, or, 22 is a two-story building. So, discussion here is building 18A, 17A, 19, and 21 and 22, are they separate buildings? Is the discussion here. Now, you can get, once again, you should keep it on a very simple basis of, to me, if this is the nomenclature of the lot, and how the owners actually specified it, that building 18 AA is a different building than 18A. That's different than 17A. They have a different number. There's a little architectural wall connection between 17A and 19, which makes it a different building on a very simple standard. There's some little
It's a full second story.
architectural little wall between the two there, whatever. There is a connection where there's a bridgeway.
But it's a usable second story.
It's a second
Apparently
story.
so.
full
So
second
17A and 19 could be considered one building.
Absolutely.
Now, let's go to the next one, 19 to 21. Is that one building?
There's a contiguous roof line and common wall space. It's also contiguous.
And I would, just to make it even easier, if the space between 19 and 21 were a storage yard, I would say no. But it is occupiable space, it's restrooms.
It's got
and a
bathrooms and
corridor.
stuff like that in it.
So it is a full.
And the slot between 17A and 19 is their suite up the VIP area. And so 21 and 22, 20 are also continuous buildings, is that correct?
Well, it seems to me if there's
That's one
some,
interpretation.
if there's some sort of physical architectural connection between the two, then they should be considered one building, right?
I think more than just architectural connection, there's a functionality connection.
Right.
There's a functionality connection between 19 and 21 in that area. There's restrooms there.
Right.
There's other things, there's an upper floor you walk up to, same between 17A and 19. There's a functionality there that's probably not brought out on the plan very well, but it's...
Well, the VIP lounge is in building 19 on the left-hand side. That's where the VIP lounge
Okay,
is.
what's the connection between it and 17A? There's a...
That's it, the main room up there.
Is there an archway between 17A and
There's a
building 19?
breezeway underneath it.
There's a room up there with a breezeway underneath it.
Then it is connected
There's
then.
functionality. so
There's
there's
functionality to that. Okay, so it's
So
one,
the key term here in a way to me is functionality. between-
well, it's not only functionality, but architectural to me also.
It could be just an architectural wall between the two, and that would be...
But I like the word functionality also.
That's
Functionality is one thing, and we look at how substantial they are connected. Maybe the function rooms over there, maybe there's a circulation pattern, structure connection, but if it's merely something decorative, like archway between building 1 and building 20, I would say, no, they're separate building. But for the connection between 17A and 19, there's functional room there.
That's correct.
And the connection it's not a very small portion, it's pretty big, and it's higher than building 17.
Well, it's just- there's
Yeah.
architectural differentiation.
Right,
that
it looks
that's there.
substantial, so
So-
I would consider them the
So,
same building.
that's where I come to as far as defining the continuous building is the functionality between the two. To me, that's the critical criteria, so I would be comfortable with 17A, 19, and 21/22 being one building,
One primary
one primary.
structure, building.
All that, if I may, all that really differentiates those two spaces is that 17A and 19 has a second story, so there's a dependency on that connectivity upstairs, right? It also offers ingress, egress underneath, which is open air, and there's restrooms. But the relationship between 19 and 21 is merely a roof, because the outer wall of building 19, as it relates to 21, it's a solid, non-usable wall. There is no access points. It is just merely an ingress, egress, in and out of the mall. Building 21 has restrooms adjacent to it that are attached to that side of the walkway. So all that really connects them is a roof. Yeah, there's a roof there, but there's no dependent functionality. If you removed, I think it'd be reasonable to say you could open that up, have open air, and still have full functionality of those two buildings without interrupting any other uses within those two buildings.
And Mr. Chair, we're debating based on that chart up there. That's the source of the facts that we're debating, right?
That's correct.
We're not bringing new facts in.
Right. We've all been to the site and done our
key-
research. So.
I just wanted to be
Yeah.
clear about that.
Correct. Okay, let's see, we got lights on everywhere.
No,
Mr.
I'm
Crandall? Mr. Crandall?
No.
So are we through discussion here? Are we ready to go to the final end game here? Speak now, forever hold. Are we clear on the buildings, the functionality?
I think we're clear on the buildings. I think it's important for us to have defined that, defined and gone over the interpretation of the code, municipal code, in its entirety, not word by word, but or not one word, but for in a harmonious fashion for all of the words, and that's important that we don't pick the words out separately.
And Mr. Chair, if you do go that way, but you determine that staff did not correctly determine which buildings were buildings, then your motion is going to have to be detailed enough so you actually link up the buildings that you're determining are buildings. So somebody's going to have to make that motion with
That's
all
correct.
the linkage of which building is a building and
You have
which.
to connect the dots, that's correct.
Yeah, thanks.
I do want to make sure it's clear that I don't think staff was incorrect in saying these are separate buildings. I'm just of the opinion that our ordinance isn't clear. And the most liberal way to interpret this is that as one building. And I think that's fair to everyone. It seems to match the code. Was it the intent is not the issue. It matches what the verbiage is, and that's what we've been asked to evaluate. So I would make a motion that we're going to have to resolve this resolution.
Motion is to deny. Might be a little.
If the result of our determination is not a complete denial of the appeal, and the staff can determine that there are some that work, what do we do with the resolution we have in our hand?
There'll be a new resolution.
Do we have to wait for that to be written?
No.
Well, they can get the decision. I don't know how complicated the change is going to be. I haven't looked at the resolution, but
Yeah.
it's going to be different than the way it reads right now.
But I think we have to determine if of the ones that you are considering to be valid.
Do I have to identify?
Is it 120, have they expired with their 120 days? I think that's important, because on one hand, we have to consider the time period involved here.
Or should we just say that they would be eligible for
Yes.
reconsideration?
I think you need to send it back to staff and let them figure it
Okay.
out after you determine what the
Okay.
buildings are.
Can I make a suggestion? I think the motion maybe we confirm that the staff interpretation on the primary structure, that is correct. And they also say, out of the six permit that was revoked, 4 should be reinstated.
We need
or
to make a
reconsider.
determination
I
this
think
evening,
reconsider.
because July the 1st comes, we may have a different composite here at our planning commission.
The last meeting of this planning commission in the current
Okay,
term.
so I would make a resolution of the Planning Commission of the City of San Clemente, California, denying temporary banner permit 17194, appeal for denial of temporary banner permits, applications for outlets at San Clemente, located at 101 West Avenida Vista Hermosa, with the changes to the resolution. Let's,
Buildings.
okay. Additional to the subject permit would allow temporary banners to be displayed beyond 120 days. I don't believe that.
Well, is it possible for us to have a short recess where staff would be able to rewrite this
Well, I'm looking at the
resolution?
specific, they were appealing the findings that staff had made. The application for temporary banner assignment permits is item 1. Let's just go through each item. Temporary signs shall be placed on-site and flush on the building. We determined that it could be construed that the whole building, 17A, 19, 21, and 22, could be considered one building or is considered one building. These banners are prohibited in the following locations. The applicant for temporary banner signs that do not meet the criteria of this section cannot be approved. I think we agree with that.
Yes.
So I think item 1 is still good. San Clemente Municipal Code defines primary building and primary structure as follows. That's just a given.
Okay.
Based on the municipal definition, a primary structure and a primary building are one and the same, and that's just a given fact. Because the subject permit applications do not meet the criteria that a banner be placed on a business's primary structure, primary building, they do not comply with the municipal code and cannot be approved. I agree with that, actually. Additionally, approval of the subject permit applications would allow temporary banners to be displayed beyond the 120-day cap provided in San Clemente Municipal Code, since the banners at issue were previously approved for temporary banner permits for 120 days. Such approval would not be consistent with the proposal, and I agree with that one also. The remaining issues submitted in the notice of appeal are outside of the scope of the appeal and are not under the purview of the reviewing body. I agree with that. So the only thing I would say is that we, as far as the denial is, can we take this resolution, approve it, and then give staff direction to, in the future, determine that that one building is contiguous?
Yes.
That would work?
Yes.
Okay, I would move
But
as,
before you make the move,
Sure.
I'd like to say, regarding item 3, because the subject permit applications do not meet the criteria that a banner to be placed on business primary structure, if the understanding we talk about today is passed, and then 4 out of 6, they do meet the criteria.
That's for staff to figure out.
and what we're going to do, what I'm
So
intending
we're
to
sending
do
it
would
back
be
to
say, yes, the resolution can stay as stands, but we give staff the recommendation to consider the 17A, 8, 19, 21, and 22 as a contiguous building for re-review of the applications and comply with that understanding, and that 18AA is a separate building, 18A is a separate building, Building 20 is a separate building, and Building 1 is a separate building.
I think what we're going to want to do here is 1 and 2 would stand, and then 3, I think Commissioner Wu was right. 3, instead of leaving 3 in, you just say that the buildings, you'd lock the buildings up and determine what they are. And then number 4 would be staff is directed to act accordingly to carry out the commission's decision.
Okay, so you want item 3 to be revised?
Yeah, 3 would be what your motion is going to be, how you see the buildings as a building.
Okay,
And then
for
4 is staff is directed, this matter is remanded to staff.
Okay, then
For
item-
actions consistent therewith.
Item
This
3
resolution.
then, for staff to consider 17A, 19, 21, and 22, a contiguous building. Buildings 18AA is a separate building, 18A is a separate building, building 20 is a separate building, and building 1 is a separate building. And staff, I will refer to you for the final statement.
Okay. We have all the buildings identified? And
Yes, we do.
Okay, as separate. And then staff is directed to take actions consistent with this resolution.
As stated by the attorney, city attorney.
We have a motion, do we have a second?
Second.
Motion and a second, all in favor?
Aye.
Aye.
Opposed?
Passes 5-0.
Did you get those numbers? Did you get the numbers?
Okay. With that, we'll move on to, there is no old business. Item 11, reports of commissioners and staff. We have no future agenda, no staff waiver issues. I would like to defer Board of Commissioners to Commissioner Eggleston.
Thank you and good evening.
Thank you. Thank you. Thank you.
Thank you for your help.
Well, this is my last Planning Commission meeting. I want to thank you all for putting up with me for 4 years here at the Planning Commission. I think we've had some very good discussions, especially in the last several meetings. One was with a conditional use permit for a restaurant, and we determined that we needed to really take a look at the health and safety issues before we took a look at the conditional use permit. And I thought that was very important for us to do. And why? Because in our mission statement, health and safety is our #1 issue. And so we have to deal with that first before we can take a look at a conditional use permit. Well, our last meeting, we took a look at a variance, and we determined that we could not approve a variance in the past. It had to be in the present moment. And I thought that was very important for us to go through that discussion. And I appreciate the Planning Commission, because the Planning Commission is here to really interpret and to really define a lot. We're not here, obviously, to make policy or change policy. That's the purview of City Council to do. But I do have a sticking point that we have, and I've had that sticking point for many years, and that is conditional use permits. And I'm glad staff is here to hear this, because conditional use permits are a real bugaboo at times. The applicant spends a lot of time and a lot of money. How much is it? $5,000?
It depends on the type of conditional use permit.
Uh-huh.
But
Yes.
a deposit account of $5,000, but they range anywhere from $1,000 to $5,000.
To $5,000. So the applicant spends a lot of time in conditional use permits, and we spend a heck of a lot of time going over conditional use permits. And a lot of times, these conditional use permits down the road are not complied with by the business or the applicant. And that's a real bugaboo to me, because we spend a lot of time on this. And since I've been involved in the city, we've only taken away one conditional use permit in many, many years that I can remember. And so it's not something that we do willy-nilly. And we really shouldn't think we should depend upon code enforcement to be our savior in this, because they're involved with vacation rentals and sober living homes, and they're really, quite frankly, short-staffed. And right now, we don't have a weekend code enforcement officer out there. So, we can't depend upon code enforcement to do all these things with regard to conditional use permits. The biggest bugaboo I have are bars and restaurants that have live entertainment. And I hope staff will make a definition about what is acoustical and what is live music. Did you know that acoustical can be drums? Did you know that? So we can't define what acoustical, we can't tell them what type of instrument they can or cannot play. Acoustical can be drums. And I know that there are going to be some applicants coming up recently in the Del Mar area and one in the South El Camino area that want to have acoustical music outside. That's something you really need to consider, because that really opens Pandora's box out there. And once you open Pandora's box, it never shuts.
We're having enough time with certain inside music without open windows.
Right. Well, inside music they're supposed to shut their doors and windows when they have live entertainment going on. Some do, others don't. There's one that hasn't in the past, and they have just not been compliant in any way, shape, or form with shutting their doors and windows. And there's one that slipped by in 1999 with regard to not being able to shut their doors and windows, but we learned our lesson there, didn't we? And if we really want to make the Avenida Del Mar area a mixed-use area where people can live and work and entertain, we really need to be very careful with all of that. And that includes the T-zone. So I'm just making a suggestion here that in the future, when we talk about live entertainment and conditional use permits, that we really are very careful not to make this into Bourbon Street, Bourbon Street area out there. It's important that San Clemente really defines its family atmosphere out there. And so I'm urging you to be very careful when it comes to conditional use permits. I'd just rather have a special activities permit, to see how they do for a while before conditional use permits come along. But, so that's my words of unwisdom for this evening.
For the code enforcement, you probably know that the city already beefed up the code enforcement.
They're trying to, yeah, they're going to process.
We hired an external law firm recently. Last in the city council meeting, we revoked someone's short-term rental permit.
Right.
On appeal.
Right.
Gaviota.
Right, and
Gaviota. Denial of that variance is also part of code enforcement. So
right.
we're making good progress.
Yes, but the amount of time that code enforcement in the city took for this particular revocation of the vacation rental permit was incredible. The amount of money, the amount of staff time is really a lot. And it's important to really take a look at our code enforcement, and actually we call it code compliance now. Thank you. And it's important to take a look at that and not depend upon them for everything.
When we built that ordinance, though, we had to build in due process into it, which makes it quite a bit longer. But,
right.
Wayne, I'd like to say, I was 12 years on council, been a mayor, and city council member now, 4 years with us. You came in right as we finished up the general plan. Here's 900 pages to read, and here's a program EIR, another 900 pages to read. And so you dug right in, and it's been great.
Thank you.
Thank you for your 16 years of direct service to the city. You've had a great impact in so many areas, and your continued effort with the Marines and, Camps Park Semper Fi and our battalion, and so your total community outreach, I think, has been awesome.
Well, thank you. And
You're
design.
still buying the next hamburger, by the way.
Oh, yeah, right. A design review. I want to put a plug in for design review. What a terrific, terrific committee. Years ago, it was more dictatorial, years and years and years ago. But it's not dictatorial now. It's by suggestion. And I have to tell you, I'm very impressed with design review out there. That's an incredible committee.
You've been a big part of it, too.
Well, I'm not technical about it, but I can see a bad project, when I see one.
You're invaluable part of it, and like your common sense approach. Although you're not a professional architect, but sometimes your comments are right on.
Great leadership.
Sometimes, he says. I object to that. I object to that.
Well, other times you're silent.
It's brought a great, I think, deal of experience to the table in that, and a way he goes about conducting that meeting and what he does. I've had a lot of feedback from applicants.
That's terrific.
Positive about design review, and so it's a very key component. I consider that, the output of that group to be polished when it gets here, so the design issues should be fairly well ironed out. We shouldn't be moving any structural walls on the dais here, that's all been hammered out. We're working at then the site plan and the conditional use permits and the larger level here, that I've come to really rely on the design review subcommittee and the hard work they do, and the staff that puts together all their efforts that gives the design review something to work with. That's a key cog, I think, in the last.
It's been really terrific.
It's absolutely, I think, critical that the output of that, the way it's structured and convenient, so that the applicant, and you see it in the staff notes now, we put it in there, how many times they come back and they change what the staff and the design review subcommittee has requested.
Well, we're lucky that the three of us all go about it as we're there to help the applicant get their project approved.
Absolutely.
We're not there to dictate anything.
You always start
to
every meeting that way. What are you here for?
We're here
I
to
know what
help
you
you
do.
get through the process.
Yeah.
So it's the staff and the design review subcommittee, what really knocks a lot of the rough edges, a huge amount of rough edges off before it
Right.
comes here.
I would suggest that anybody that wants to run for city council, first run for the planning commission. And I want to thank staff for all they do. I know it's hard. It's very hard, and I want to thank, Adam for code compliance. We don't call it enforcement anymore. And I want to thank Bill Keene. Thank you. You've been a great asset in our business council meetings for the Chamber of Commerce. And thank you, Cecilia. You've been terrific, trying to organize all of these parts that just, that come together. And I want to give a special thank you to Amber for her commitment to the Miramar. That was the most incredible staff presentation I think I've ever heard in all the years I've ever been with the city.
It's a new chinning bar.
That was incredible, and the staff
We
report.
expect them all to be that way now.
Yeah, we're gonna take each page of that staff report and frame it and put it on the walls around here, because it was an incredible, thank you so very, very much, Amber. It was just wonderful. So it's been good. I'm not through, though, by the way, with the city, so.
I'm sure you'll be watching us on TV. If we get too far out of the box, you'll be running in here with your rainbow sandals on.
Have your phones on so I can text you.
Wayne, did you know that the city attorney suggested that we might, in contempt of the court order on Miramar, by approving that?
Yes, but that's been corrected. That's been corrected by the Scott.
But the court order is about the withholding of the building permit, not the CUP, right?
Right, yeah, and the permit for the Miramar is going to be quite a while away.
Right.
And of course, we're going to be all through with this.
We didn't
Soon.
approve.
Coastal
the
development
building
permit to
so we're not
go
in
and other
violation.
things.
No.
Do you have something more you want to
It's not,
say?
no, so.
So I want to
We can
thank
wrap
you,
it.
Wayne, for setting a great example for all of us here. Your tireless commitment to the community has been inspiring, and so the modeling that you've created is inspirational for us. I know it's been all of us and future commissioners, so thank you for that.
Thank you very much.
So
Thank
to
you.
wrap this up, I'd like to say thank the commission tonight. It's a very difficult subject, that we had to plug together, tough, with staff. I think we reached a pretty solid, I think, conclusion here. And thank you all for great work tonight on the dais. So with that, let's go for an adjournment.
I want to do a quick one. I just found out tonight, I'm behind the time on Amber's new position, and congratulations on,
Oh, I didn't know this. What is the?
Yes, Ms., would you like to share, please, with your...
Introduce yourself.
What's your new business
I am
card?
fortunate enough to now not be the interim city planner, but
wow.
the city planner.
Cool.
So thank you very much.
Recognized, and she certainly
So
deserves it.
Cecilia, we come...
Congratulations. You trained her well.
Can you get out with some sort of announcement, or is there some problem with the city manager that I need to intercede?
We've been busy.
Yeah.
Really?
You get all new furniture, is that correct?
Laura is
now?
Laura.
Is that right?
I already did.
Oh.
Just kidding.
I know
I'm just
exactly
kidding.
what she said.
I'm just kidding.
Should I send her an email, or you need help, or what? Enough. Okay. With that, let's make a motion here to adjourn. Mr. Eckert, would you do the honors of...
Yes, if I can find it in here. Where am I? Okay, adjourned. I make a motion to adjourn to the adjourned regular Planning Commission meeting to be held at 6 p.m. on July the 19th. I will not be here. 2017 in council chambers at City Hall located at 100 Avenida Presidio, San Clemente, California. I might be on the phone, though, to you, texting you, so.
Well, I second that.
Okay, a motion and a second?
Before you prove it, it's adjourned to the study session. We'll have a study session at 6 o'clock that night.
Study session, okay?
Thank you.
Okay, so
Motion and a second, all in favor?
Aye.
Opposed? Passes 5-0.
Can't believe it.